Hey, what's up, guys? Welcome to Law-splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today it is time to pick up where we left off the other day, I suppose. Mystery tea hovering in from the side. Thank you. What? Shuttish. I love you. Good night. Oh, guys, get ready to lose No Nut November because it's the 16th. And if you're on 16 days, I don't believe you. I don't believe you at all. Okay. We've got a document that was filed late Friday. And after I had already announced I wasn't doing a show, a document was filed. And so I figure I should probably talk about it. I should probably talk about that. We can discuss it. We can discuss that. The document, we'll go through it. It's pretty straightforward. You probably have seen it. I would think. Have you guys? I hope so. If not, we'll go through it. We'll talk about the theory about it. Maybe we'll take a peek and try and figure out what they're looking at. I don't know. It's a Saturday. I cooked gumbo today, which means I definitely had a hot date. As we all know, the best date night dinner you can cook is a good solid gumbo. Thank you, Maddox. But yeah, so very chill. I've had a couple. This is not all me. I'm gonna get blamed for this. This is not all me. This is a new liquor that I have never tried. We had dinner guests today, and they brought over a liquor. It is this Buchanan's Deluxe. This is a blended Scotch whiskey. It's very, very smooth. Very smooth. It's only a 12-year whiskey. It's blended. It's not single malt. Normally I would turn my highbrow nose at such a thing. How dare you? How dare you? Single malt and nothing. It's quite a competent whiskey. Very smooth. I have a little bit of whiskey left, but I did not drink the half bottle. So, don't blame me. This is actually what's left of Lady Rackets' shot, and what's left of Lady Rackets' other drink, this Smirnoff Hurricane Punch, which is absolutely, it's like I don't know, it's like orange strawberry crush mixed. It's not very good. It's got some pineapple in it. I don't know about that. But we gotta get rid of that. So we're gonna talk about the Vic stuff. We're gonna talk about the Vic stuff, and then we're going to do just some some general chat about some legal news topics, just some fun stuff for a little while. I don't know how long the stream is gonna go. It might go 2 hours, might go 3. I don't know. I can't see it going 3. But a couple other quick things to mention. I did get channel memberships on my channel. These are a subscription that you pay to YouTube. And the split is the same as a super chat, okay? So it's 70-30 between the creator and YouTube. I'm going to add them. I don't think we have them activated yet. I'm going to add them, but I don't want to just add them. I want them to add some sort of value to them, because I can't make it the same as a Patreon subscription. It doesn't work that way. I don't have a way to grant Discord access based on subscribers or anything like that. So I can't do it that way. So I don't know exactly how to implement it. It allows you to do levels and stuff. We'll be implementing a very basic level that'll have badges and emojis very soon. So keep an eye out for that. If you want badges and emojis, if you don't want to participate in it, don't. Magic. But at some point I want to make it an additional value for people. Again, I don't want to just have money options. I want to make them add value for people. So be just cognizant that at some point, oh my goodness, it's hot. At some point, I will flush out the idea and announce it so that people can participate and get something out of it. Exclusive streams or something like that. I don't know what exactly we're going to do. Got to talk about it, right? Got to talk about it. Let me get the documents pulled up here. Be just a minute while we do that. Oh boy, I'm not yawning. Not yawning at all. We're not tired. It's not a Saturday. None of this is true. Oh boy. So what do we got here? Here we've got this is the one. Right? Okay. Let me get it. So what are you guys up to today? How is your weekend going? Oh, I should say I nailed down Camelot 331. He's the guy doing sort of the tell-all on GameStop. Sorry. He's the guy who's been doing the tell-all on GameStop. He will be on the show on Tuesday night. So I'll be advertising and promoting that as much as possible over the next couple days, because I want people to know where they can come get his story. We'll find out about his lawsuit, what he's being threatened with, by whom is he being threatened by? Who is he being threatened by? By whom is he being threatened? We're going to figure out all that stuff and see kind of what claims they have. I have no idea. All I know is that he started talking about GameStop being like, employees in the break room are calling people hookers or whatever. And then suddenly he's getting threatened with lawsuits, which is great. So that's what we want. We want a litigious world full of litigants, and we're going to do that. Now that FPS Russia is out of jail, can you see about getting him on? I would love to. I would love to have Kyle on. Learn to talk peasant? I sound like an owl? That's weird. Oh, and I'll announce it now. At the end of the show, yes, I will be migrating over to Twitch for some chill Neverwinter Nights 2 gameplay. My Warlock is finally still terrible, but getting better. All right. So I've got some chats to do, and then we will go ahead and delve into this. Mr. Archer sent 4 chats, but all of them combined hit that $20 instant chat limit. So I'm gonna do them all. Mr. Archer says Epstein. Mr. Archer says didn't. Mr. Archer says kill, and Mr. Archer says himself. So there you go. Apparently those are 4 very important messages that need to be shared. So Epstein didn't kill himself. We've got RZEQDW says, if I still lived in California, I'd be in jail right now. But because I live in Texas, I owe the government $300 instead. Yay, Texas. Oh man, I got a phone call from a government employee the other day. Who, and he caught me right as I was waking up. I was not ready to wake up at all. And gave me some news that I didn't want to hear. So I was like yelling at the guy. I felt bad later, but I didn't, because since he works for the government, he has no soul or personality. And I was like, I hate you commies. I hate you so much. I don't understand why you exist. I don't get what your problem is. And you should leave me the hell alone. It was good. Okay. All right. Let's get... I've got the document here. Got the document here. Let's... there! Guys, I feel like I haven't streamed in a year and I don't know what I'm doing. I think it's a combination of the fatigue and the whiskey and the day off. We've got a big announcement. Not a big show announcement. A big announcement that's great, that is tangentially related to the show. I'm going to do that in just a little bit. Let's start with this document, then we'll announce it in just a minute. But it's not really like, don't get your hopes up or anything. It's just a fun thing. It's a fun thing, a good thing. Victor Mignogna versus Funimation. Now comes plaintiff Victor Mignogna and files his motion to continue hearing on November 21st, 2019. In support thereof, plaintiff would respectfully show the following. Plaintiff asks the court to continue the hearing currently scheduled for 10:30 a.m. on November 21st, 2019, on defendant's several motions for attorney's fees and sanctions. Plaintiff asks for this continuance on the grounds that more time is needed to sufficient. That's where it stops. Or more time is needed to sufficient. I think the inference would be sufficiently address the motions. I think that would be the inference, but they did leave off whatever is supposed to follow the T in sufficient. There's something. This document was not written by Ty. This is not a big deal, frankly. I mean, it does look sloppy, but if you guys only knew. Oh my goodness, hold on one. If you guys only knew how sloppy legal writing actually is on the common. It is not a wonderful world of tight writing and no typos. People are working against deadlines, they're working on multiple things, they're doing copies and pastes and all sorts of stuff. But it is always funny to run across something like this where it's like, needed to sufficient. Okay. All right, anyway. On November 21st, 2019, the court is scheduled to hear argument on 3 motions. Defendant Funimation's motion for legal fee, reasonable attorney's fees, costs, and sanctions. Jamie Markey's motion to determine sanctions and attorney's fees. And Monica Rial and Ron Toy's brief in support of sanctions and attorney's fees pursuant to Texas TCPA. The court has set aside 2 hours to hear evidence and argument. In striking simultaneity. Is that a word? I'm checking. I know what they mean. Oh, wow. I mean, it kind of is. It's it's like a physics word. Okay. Simultaneity. It means they're simultaneous, but it's like a physics word. Okay, sure. But maybe they mean it, because I think it's simultaneity in physics, and I closed the Wikipedia page. I'm not actually reading this. I'm just going off of what I think. So if I'm wrong, make fun of me if you know. but I think it's related to like entangled pairs where things happen at the same time across a distance where both events can't necessarily be observed to be simultaneous by the same observer, but they are simultaneous, just distant. And so maybe he means that. Maybe he means that, but I think it's just maybe just pulled a thesaurus word out. And striking simultaneity. I'm going to get good at saying this by the end of the night. All three of defendants' motions were filed on November 4th, 2019. Okay, so here's what they're doing. Like, this is trying to plant that seed. These guys are working together. This is part of a conspiracy, obviously. I mean, anybody pretending that this isn't part of a conspiracy needs to find Epstein's cell. But the reality is, of course, this is a conspiracy. It always has been. The question is not whether or not this is a conspiracy, and much more a question of whether or not you can show evidence of conspiracy. Those are two strikingly different positions. There's no question that Monica and Ron talked about this, right? Like, that's obvious. Monica and Ron were acting in a form of civil conspiracy. That's not a theory. That's not a wild thing. They discussed this. They participated in phone calls. They had similar objectives. This is what was going on with what they were doing. They clearly discussed tortious acts against Vic Mignogna and acted on them. I would argue that there's plenty of evidence that Monica and Funimation were involved in the same sort of conspiracy. There's a lot of emails back and forth between them that go to that talk about various things. Now, whether or not that conspiracy was as conscious as it looks on the surface is a different question, although I definitely think it is. I don't think, and the positions that the parties have taken only really seem to reinforce that idea, in my opinion, but I could be wrong. I don't think so. I don't think I'm wrong. And then the hardest one to prove is Jamie Markey. She might be just the dumb ox that barged in. She really, like, that's her defense in all this is, no, I'm just the dumb idiot who barged in and started blabbering because I saw my friends were taking heat online. And she's actually said that basically in Facebook messages to people. That she just went in to back up her friends and all this stuff. So is Jamie Markey part of the conspiracy? I mean, it depends on how much she discussed stuff, but she has at least an argument that she's just an idiot, a fat dummy who tumbled into a problem. So good on you, Jamie. That's Mike Dunford's entire life is what I just described about you. So don't feel bad. Okay. So that being said, they're planting the seed back in Chup's mind here. This is a conspiracy. They're working together. Not only that, their billing shows how much they're working together, which is a lot. A lot of very expensive meetings between co-defendant counsel. And maybe it shows some other relationship between the co-defendants. Collectively, they seek attorney's fees and costs exceeding $500,000. Additionally, each defendant separately seeks sanctions against plaintiff. Defendants' motions with their offered exhibits totals 483 pages. Plaintiff's counsel is obligated by law to adequately present objections and responses to these motions, a task that is currently underway. However, plaintiff needs more time in order to adequately brief the court on the myriad of objectionable time entries in each defendant's billing. Plaintiff therefore asks for a continuance of at least 14 days. Plaintiff seeks this continuance not for the sole purpose of delay. Remember, it's not in the best interest of the plaintiff to delay here. As I've been saying, actually, it's kind of in the interest of Jay-Sean to delay. With the appeal pending, it would be better. It would be better for the purposes of the pending appeal, although the pending appeal isn't that big of a deal. If they have to lose the filing fee on it and then appeal again, that's not a problem. We'll talk about that in a minute. But with the appeal out there, it'd be much better to get a ruling on the books so they could just go through the appeal. They can moot any weird issues of, well, this isn't fully ruled on or it is fully ruled on. They can just moot all of that and move on. But alas, they're trying to adequately deal with the requests for attorney's fees. And let's be honest, the attorney's fees are all heavily padded. So they're not for the sole purpose of delay, but so that justice may be done. Now, what are my opinions? So this is it, and they've got a I don't have it in here, but they've got a proposed order as well, just granting the continuance. So what is it? What's up? What's up here? What's Chup gonna do? I don't know. There's a couple schools of thought we can go into. One is that Chup wants this off his radar. He's going to let the appeals court deal with it. If that's the case, and there's stuff to support that, him denying the deposition of Slaytosh would be one thing to support that. He says, no, just do it at oral argument or get your brief done. You've had time. No more delay. Let's get it done. That's possible that Chup wants to do that. If that's the case, he denies the request for a continuance. For what it's worth, this was filed on Friday, so we don't have any input on whether or not the opposing counsel has mentioned anything. Oh, no. It says a conference was held on November 15th with each of defendants' attorneys via email on the merits of this motion. They could not reach... It was resolved the dispute without the necessity of court intervention. So, apparently, the other parties did not agree to the continuance. And of course, they don't want to give more time to Vic to figure out their billing. They just want to go in, right? That's the idea. And that's fine. There's nothing nefarious about that. That's just what they want to do. Okay? But, so they have had a conference on it. Now they need the court to determine will there be a continuance or not. They're going to argue no on the continuance. The court will determine whether or not they should grant it. Like I said, if Chup wants to just be done with this, he will not grant the continuance and everything will happen 5 days from now on the 21st. If Chup wants to grant them, maybe he'll split it down the middle and say you get a week extra, something like that. Don't know. We don't know what they'll do, but they're pushing against Thanksgiving, and that could be a scheduling problem as well for some of the attorneys. So who knows? I'm not saying anybody has a good or bad claim to this. I'm saying that Vic's side is clearly attempting to show that there's something wrong here with the filings, and more than just a good faith sort of. Hold on. Okay. They were, sorry. I found out why RZEQDW should be in jail. Good job, buddy. So what you normally do with the fee thing is there would be maybe a little bit of bickering back and forth over the fees, but not a huge fight. This looks like it's going to develop into some sort of like a full-on fight. The question is, when you present your attorney's fees, are they facially reasonable? If they're facially reasonable, you might go for like, well, okay, we're going to reduce it by this amount because we think maybe these hours aren't as necessary. So we'll reduce it by a percentage or whatever, which, as we covered before, the defendants have already done. Oh, we reduced our bill by 19% by going through and blah, blah, blah. But yeah, so they contest over it. They fight a little bit. They reduce the fees, and then they go ahead and award them. In this case, it looks like they're really trying to get specific on addressing these fees and really break down why they're wrong. So this is shaping up to be more of a fight than might otherwise occur. So who knows? Who knows what Chup will do? If Chup really wants to get into the fee fight, if he's intrigued by the notion that the fees are duplicative or excessive, then maybe he'll allow for extra time. I don't know. I'm of the opinion that Chup will not. Mainly because I think my operating theory on this is that Chup wants to get this out of his courtroom. And in that case, he doesn't want to have all these disputes. He didn't want the deposition of Slaytosh because it adds time and a bunch of stuff. I think Chup's going to say, nope, bring it on the 21st, argue it, and we're going to move on. That's my opinion. And I'm guessing that if that's the case, they'll be ready to go. But if not, if Chup does award them the extra time, they would, they're trying to do as good a job as possible. I have a feeling they're already hard at work on this bill. Why can't a third party determine fees? Well, I mean, you do bring in third parties. You bring in expert witnesses to testify about fees. What's reasonable, what's not, what should be in there, what isn't. That's part of how you argue about fees, but the judge is empowered to determine the reasonable attorney's fees. What's Chup going to do if it goes back to him after appeals? He'll listen to the appeals court and then do what he's supposed to do. Or not, and then it'll get appealed again. But I don't think this is going to be remanded to Chup. I think the appeals court will, because there's problems with remanding the TCPA back. Do you get to add to the record after a remand? Now we're way past the statutory deadline for all of this stuff. What do? We've got a record that exists. The appeals court's going to look at the record. The appeals court should just determine, does this pass TCPA or not? And then it'll go back to Chup, and then we will be past the TCPA if it does come back on appeal. It's not like they're going to go back and redo the TCPA. Most likely. In theory, that's possible, but they'd be able to introduce all sorts of new things into it. And so that's problematic. That's problematic for the process. I think it's the most likely outcome is the appeals court's going to say, no, these should have survived TCPA and these shouldn't have survived TCPA. Move on, go. That's the likely outcome. Maybe they say all of them should, maybe they say none of them should. But I think the appeals court is going to issue a ruling on it and then send it back down to the trial court to go for further proceedings if any of the charges survive. It's Buchanan's. Really? This is I'm not going to have too many more because this is my third one. And that's going to be a lot if I keep going after that. But it's really quite good. Then do we get the affidavits that were left out? You can get, after TCPA, you can introduce all sorts of new stuff for trial or for summary judgment or whatever. That's a whole different ballgame. That's a different thing altogether. So, right now the record is only limited for the purposes of TCPA. After that, you get discovery, you get you get to introduce new evidence, new witnesses. All of that stuff comes later, like a normal trial. So if this gets past the appeals court, even on one issue, we're going, for all sorts of, oh my goodness. We're going for all sorts of stuff. We're going to see all sorts of stuff, I should say. All right. So let's take a peek at the billing, shall we? I didn't do this before because these are long. Where are we? Long documents that are very boring. But let's start taking a look because, I've looked over them and I saw plenty of things that are problems with the bill. Stuff that shouldn't be paid for by the plaintiff. Let's see if we can find some. Let's pull up Lemongrass's thing here. I'm gonna skip over his stupid argument and we'll go straight to the bill. Oh, hey, do you guys want to see the really nice chapel in the hospital my grandparents built? It's relevant to this lawsuit. That's why they included it. Do you want to see it? That's the chapel inside the heart hospital. If you're ever in Tyler, Texas, I would strongly recommend you take a stop in there. The stained glass is absolutely beautiful. The chapel's beautiful. The hospital is wonderful. The staff is great. So you can see it there. Yeah, this is I don't know what this has to do with the lawsuit, like why they're trying to include a heart hospital in Tyler, Texas, as somehow relevant to a lawsuit. But I don't have brain AIDS from a dirty mosquito like Lemoyne does. So I guess that's what that is. But if you wanted to see it, there it was. It's really nice. Just scrolling through these documents. Kiwi Farms. This is where Lemoyne thinks I'm either Captain Manning, which is just rude to Captain Manning. I am not Captain Manning. Don't put that on him. That's mean. Or he thinks I'm mindless observer. Neither one being true, of course. Look at that. Hey, who's this guy? I was looking all good that day. I had it shaved. It looked like I cared about life. Oh my goodness. Oh, the true authority that is CBR. Thank you. This is all relevant. I hope you guys realize this is relevant. Oh no. Oh, this is a Minnesota Lawyer article. That's right. Good picture of me and Vic. The death threats from the guy who explicitly stated that he's not with either Kick Vic or I Stand With Vic, Gold Reaver, but apparently is somehow pushed on by me. The GoFundMe. Oh, you know what we got to do. Sorry. It's a rule. We're the rules party here. GoFundMe. Vic kicks back. Here we go. We've got a GoFundMe here. $261,347. Thank you to Davian Bowens, Anonymous, Emily Woods, William Stevenson, Matthew Cunningham. Thank you guys for your donations. Very generous, very wonderful to keep supporting Vic through all of this. So thank you. Just since Lemoyne put it in there, I got to do it. Okay, affidavit of J. Sean Lemoyne. Let's see. Can we get to the billing? Oh my God, what an insufferable pile of trash. Okay. Here we go. I apologize. He included so much frivolous crap that it took a while to scroll through it. Let's see. All right. You have a hoverboard? Hoverboards don't work on water. All right, so Wick, Phillips, Gould, and Martin LLP, billing timekeeper, J. Sean Lemoyne. Notice who his client is. His client is Kessler Collins. J. Sean was hired by the law firm that is representing Monica Rial and Ronald Toye. Clients are very important. Clients are very important. So Kessler Collins has hired Jay Sean. We've got bill date, November 3rd. Begin date was apparently January 1st of 2006. End date was, it's probably when they picked up their billing software. This isn't anomalous, or like, this is fine. They're just making sure they capture all of the dates that exist. Let's see. End date, October 31st. Date of last payment, October 7th. Amount of last payment, $86,583. Which, I'm curious, kind of curious who paid it. Who paid the $86,583 that they billed? So here's the, here's those numbers. These two combined must total up to that. That's just how far delinquent they were, plus another. Okay, so hours 462.40, billed 391.60, incurred $223,069 in expenses, billed $184,000, collected $104,282. Again, the question is, who'd you collect from? Expenses, here we go. From inception to date, it's the same thing. Year to date, blah, blah, blah. Bill remarks. So here we've got all sorts of stuff. So here's your first an immediate problem with their bill, right? Prepare for TCPA mediation. Conference call with client regarding mediation. Review and analyze plaintiff's production. $1,131. Note, Dragon. Court said that each party would bear their own expenses for mediation. So this is an immediate problem. So that's EAM. That's one of the other people at the firm. Jay Sean, prepare for mediation. Continue researching law. RE contours of sanctions and decisions upholding sanctions. Outline affidavit of attorney's fees. So he has lumped these two together, but mediation should be borne by the parties. So mixing those two is going to be, how are we going to justify that billing? $1,545. Attend mediation. You've got $7,000 in mediation fees here. Preparing for and attending mediation. And then this is a problem. Mediation costs are supposed to be borne by the parties. So we've got $12,000. 11 to $12,000 that shouldn't be on there. Straight up. So it probably took them about no time to figure out that they needed to actually go through the billing. What is a dragon used in this? It's probably Dragon Ball. Reminder, this note is created by the timekeeper EAM, who is not Jay Sean Lemoyne. So he's just noting that this is the case that he's billing for, most likely. Research and analyze cases concerning sanctions in context of bad faith mediation. Review and analyze rules. Bad faith mediation. Sure. The mediation that was ordered by the judge and agreed to by all parties is somehow bad faith mediation. Good job. Monitor harassment and abuse of clients following TCPA dismissal. Oh my goodness. Watch out. Watch out. Pursue strategy. RE attorneys' fees and sanctions. Update legal research. RE attorneys' fee awards. Revise affidavit. RE same. Review co-counsel fees. So now they're charging for the time that it took to prepare the fees. This isn't related to the TCPA. Let's pull that up. Chapter 27. Let's see. So this is a question that's likely going to come up. 27.009. Now I have not researched this. So I'm not making a definitive statement here. I'm saying what you would probably argue if you're on Vic's side, okay? Let's see. So except as provided in subsection C, if the court orders dismissal of a legal action under this chapter, the court shall award to the moving party court costs and reasonable attorney's fees incurred in defending against the legal action, and may award to the moving party sanctions against the party who brought the legal action as the court determines sufficient to deter the party from bringing similar actions. This is the new version. Hold on. Let me see if I can find the old one. I can pull it up. Okay, give me just a second. I don't want this. Sorry. I want to pull up the previous version of the statute to make sure we've got the proper wording, because I'm pretty sure that section changed in that is this it? No, this is the same one. Look at the prior version. I don't want to pull up Westlaw, but I will. Give me just a moment here. Get rid of that. Texas. Save. 27.009. What? Oh, we got a couple justice chats here. Siren Jag says YouTube voice. What's YouTube's voice? Your ass belongs to me. I tell you what you can and can't do with it. Do you understand what I'm saying to you? Shut up. Now you whores sit down. I want to talk to you. Anybody thinking about leaving here is going to find my left foot, square up their ass. Do you understand me? Shut up, you chunky whore. I'm talking to you. These two bitches that left, they better learn to sell pussy in Iceland, because if I ever see them again, I'm going to cut their effing throats. We're family, and that's what we're going to stay. Now, I got important business out there today, and when I call you, I want you to come out there and shake your asses proper. You hear? Huh? Now, Nick, get out there and make it look good. Move it. What is that? What is that? I don't even know what that was from. Okay, here we go. Let me get the previous version. Oh my God. Where's my version history? History. Versions. Here we go. Okay, here we go. Let's here's the original. Oh, that was lovely. I don't want that. Here's the original. Okay. So the original one is, if the court orders dismissal of a legal action in this chapter, the court shall award to the moving party court costs, reasonable attorney's fees, and other expenses incurred in defending against the legal action as justice and equity may require. Sanctions against the party who brought the legal action as the court determines sufficient to deter the party who brought the legal action from bringing similar actions described in this chapter. So that's the original statute, which is slightly different, very slightly different. But the reason I wanted to make sure, so the what they're talking about is the legal action. Okay? Legal action is defined as legal action means a lawsuit, cause of action, petition, complaint, cross-claim, or counterclaim, or any other judicial pleading or filing that requests legal, declaratory, or equitable relief. The term does not include these things. Procedural action taken on motion made in an action that does not amend. Okay, that doesn't matter. The main thing here is how much, what scope do the fees entail? Does it entail everything that the defendant incurred, all of the fees that the defendant incurred in the entire lawsuit? Is that what's covered, or is it just stuff related to the TCPA itself? Because in this case, we have defendants requesting depositions, going through some level of discovery that they could have avoided. They chose not to do that. So are they defending against the legal action through the TCPA by engaging in that discovery? Many people would argue no. Some people would argue yes. That's going to be probably a big source of the contention here. These fees are not related to the TCPA or defending the TCPA. What's related to the TCPA is filing the motion for TCPA and then drafting any motion responses, compiling evidence related specifically to it, all of that stuff. That's what they're likely going to be arguing, at least in part. So that's, here you go. Monitor and investigate hate mail and death threats sent to clients following TCPA ruling. Research use of threats in sanctions. Did the client send any threats? No. No. Actually, we have no idea who sent the threats, who they're affiliated with. There's no evidence to tie them to the clients. So why should we have any payment of $783 being paid to the clients here? For what? What did the plaintiff do to incur this fee? Multiple communications RE death threats. Another $1,700 for death threats that have no connection to the plaintiff or even to anyone the plaintiff can be reasonably associated with or even unreasonably associated with. So why, again, this is $2,500 that they're attempting to charge to Vic for something that he had nothing to do with. Outline legal research, RE sanction cases, continue drafting attorney's fees affidavit, continue outlining sanctions motions, just another 2.5 hours. Revised disclosures. This is an obscenely padded bill for the drafting here. Continue revisions again to attorney's fees, affidavit and sanctions briefing. Attention to letter addressed to the court, draft motion to dismiss the appeal. Research cases concerning sanctions discovery. Review deposition transcripts. Review and analyze information concerning affidavits. They're really trying to add a whole lot into this bill. I mean, just padding hours. Pursue strategy. What does that even mean? RE depositions and document requests to Slaytosh and Ty Beard. These have nothing to do with the sanction or with the TCPA or the sanctions. They should be tossed out. Revise subpoenas. Review premature notice of appeal of TCPA ruling. Let's see. This is a problem. Why do we have a redaction in a fee statement requesting money? Mithrin Emra says, Lemon Boy's billing is as questionable as his argumentation. He is trying to accuse and bill for Vic of the actions taken by unrelated third parties. He also keeps trying to shoehorn you into things. Dude is insane. Oh, don't think that the amount of time Jay Sean has spent on Vic spent on me has escaped notice. Oh my gosh. Let's see. What do we got? We'll get to those. Those are in other bills. And notice all of these were basically awarded. Almost all of these fees were incurred after winning on TCPA. So, I won on TCPA. Now I want $34,000 more. So they have every incentive to pad the bill following the award, especially. So that's great. Who paid the bill? Who paid the bill? That's my question. Who paid for it? Well, part of it. Part of it. So then we've got some more here. Let's see. Continue preparing reply. Prepare declaration, RE motion to strike affidavits. Conduct legal research, RE striking false affidavits. Background research, determine where witnesses are located. Let's see what there's some stuff in here. Hold on. Attention to emails related to strategy for hearing on motion. Just almost an hour from this guy. Hold on. Draft and revised hearing outline. Attend TCPA dismissal hearing. This is preparation for hearing and attend hearing. Draft subpoena to Nick Rekieta. Help prepare for hearing on anti-slap motion to dismiss. Wait a minute. I haven't been served a subpoena. What is this? Let's see. The TCPA hearing was that day. How does a later billing help prepare for a hearing on anti-slap motion to dismiss? So they're billing for something that occurred after the hearing for preparation for the hearing. Okay, that's interesting. Appeal options with co-defense counsel. This is always, these are interesting, right? Pursue appeal options with co-defense counsel. Which co-defense counsel? Are they talking about Casey Eric? Or are they talking about Funimation? Are they talking, are they talking about Sam Johnson? Pursue strategy, RE sanctions and attorney's fees recovery strategy, RE court hearing. Prepare for and attend hearing with client. Pursue strategy, RE mediation. And D. Seidler. Confer RE death threats issues. The death threat issues should all be stricken. Let's see. Review mediation and correspondence from mediator. Outline legal issues. Pleadings. Let's see. Yeah, let's find the client communications redacted. Prepare for mediation. Who's redacting? What are we redacting? You're asking for money. I don't know about who's this redaction. Discussion with client. Who's the client? Who's that? Discussion with client blank. Isn't your client Monica Rial, Ron Toye, and Kessler Collins? Why would that be blanked out? Who's the client? Confer with co-defense counsel. Blank. Who is it? What's this? You're asking for $2,000, 4 hours. See. Excuse me. What else do we have here? Prepare response, supplemental objection. Continue preparing reply. Conduct legal research. Are you similar malice fact pattern? Similar malice fact patterns? Who's malice? This is prior to the TCPA. Are you saying that your clients have malice? That's a joke. Of course, that's not legally binding or anything. Don't. I'm joking. Confer with co-defense counsel. Continue revisions to supplement pre-drafting. Strategy. Continue working on supplement. Let's see. Division of Labor. Strategy conference. Outline additional research. And briefing issues. So again, he's who's your strategy conference with? Let's see. Review, analyze plaintiff's response and additional pleadings. Research notary fraud. Let's see here. Go. Finalize preservation letters. This is back in July. Let's see. Oh. Conduct background research on Rekieta for motion for leave. What's this one? I mean, it's only $37, but what is it? What's your background research on me, buddy? Why are things blanked out? That's a good question. It's a very good question. You're asking for them to pay for it. Oh, just trust us. Just trust us. Let's see. Oh, here we go. Pursue strategy RE deposition of Rekieta. Good luck. Remember, this is back in July when they were definitely gonna depose me. Notice they haven't pursued that at all. They told the court they were going to, and then they didn't. Why? Because it'd be stupid for one thing. But why do you think you get to bill Vic for your weird fetish with me, Lemoyne? It's No Nut November, buddy. Stop watching. Let's see. Prepare anti-slap motion. Review depots. Pursue strategy. Research malice cases and qualified privilege. Review various shock jock statements. Conduct online research. RE various exhibits for inclusion with the Lemoyne Declaration. Here you go. Various shock jock statements. $5,800. Sure, buddy. Let's see. These are good. He spent $1,200 of the client's money, researching how they would qualify under the Communications Decency Act. I can help you. They won't. They won't. Twitter would. They're not a platform. Twitter is. And they're literally republishing affirmatively by a retweet. It's not the same thing as Twitter, which doesn't take any, allegedly, takes no editorial control over what's posted on its website. Someone posts something to Twitter. Twitter doesn't go find something and then post it. And if they do, that's on Twitter's Twitter account. And that is a separate issue than whether or not it's uploaded to their platform against their will. So here you go. They don't. There, I saved you 2.5 hours. Let's see. Man, if I were his clients, I would be questioning all this billing. So let's see here. Especially if they paid for it. But you didn't, did you, Ron? Ron and Monica didn't write an $86,000 check to Jay-Sean Lemoyne. Didn't Ron say that he paid over $200,000 in those messages? Is Diesel here? Diesel, didn't Ron tell you he paid the $200,000 and that he paid over $200,000? That's weird. So Ron lied. I mean, shock and awe, but we can see that as of, as of the billing, here's the supplement. They've collected a total of $104,282.65. So they're still well over, they're $100,000 short. I mean, like I said, am I shocked that Ron lied? No. I just want to point it out. Let's see, Investigate Manana. Beard potential witnesses. Investigate Manana online. Investigate Rekieta and others online. 5.7 hours. 5.7 hours. Review and analyze documents produced by plaintiff. Revise deposition outline. Investigate Rekieta and others online. So this part probably took a minute. Couple minutes. Look, you go in and change something real quick. Review and analyze documents produced by plaintiff. Investigate Rekieta and others online. That's probably 5 of those hours. Good job. Pursue strategy. Pursue strategy. What is that? Let's pursue strategy. Oh, here we go. Meeting with client blank. Who's your client? Who's the client? Let's see. Plaintiff's deposition with client co-counsel. Speak with clients about deposition. Summarize highlights of deposition. Prepare for and take deposition of V. Magniogna. Whoever that is. Investigate individuals online. Why don't you just hire someone? Why don't you hire someone who actually is good at investigating people, Jay-Sean? Because you want to bill $500 an hour instead of paying a PI like $200 an hour. That's why. This is a problem too, right? Why is Jay-Sean Lemoyne investigating people online? He's not a professional investigator. He's charging more than professional investigators charge. Like, think about that. Yeah, I want to see if my wife is sleeping with my friend. That'll be $515 per hour. Actually, I don't care. I'll just file for divorce. Like, what is... He's not, this guy is not a professional investigator, but he's going, or, you know, a PI, right? Not a private investigator. He's not professional. But he's charging more than a PI costs. I want to know if Miss Piggy is, cheating on me. I was going to go down on her early, but, it smelled a little different than frog in there. Confer with Jay Volney, RE anti-slap strategy and defamation issues between the parties. That's weird. That's a weird one, right? Like, what is Volney doing talking to Lemoyne? Who's your client, Jay Sean? Smelled like cookies. No. You know she's hitting it with Grover anyway. He's got that thing. Turns upside down. Starts working that thing in. Yeah. Investigate plaintiff online. So here's discussion with co-counsel. Who's this? Confer with client RE what? Who's your client, Jay Sean? Who's your client? Gonzo, not Grover. Gonzo. Sorry. It's not me doing Kermit dirty like that. It's Gonzo doing Piggy dirty like that. Let's see. Here we go. Should I go to the Easter egg? I don't know. Here's the... Oh, we took off some stuff. That's what we did. Sure. Oh, look at that. Look at that handsome beast. Look at that thing. They caught him while his face stopped twitching for a second. Ethan Minshall. There's Ethan. Who else do we have here? We have Jeff Mills. This is a guy who makes a whole lot of money. He's like $650 an hour, I think. Or no, wait, maybe it was Hellberg. Maybe he was the $650 an hour. Oh, they're all super lawyers, man. Zach Farrar. Here's the affidavit of Casey Eric. Didn't they charge for the Photoshop GoFundMe? Waldorf and Staten tag teaming Miss Piggy. Oh man, the insults. The insults from those guys. So here we go. Here is... Yeah. Here's Casey and Andrea talking about their attorney's fees. All right. Here's the... Oh, this is just the TCPA ruling. Good job, Chup. Casey Eric, shareholder at Cowles and Thompson, making $275 an hour at Cowles and Thompson. Wonder what he was making at Kessler Collins. May 19th, 2019, Monica Rial. This is probably just her address. That's good that that's redacted. Current legal fees, less advance paid. They paid a $5,000 advance. Didn't Toye say he paid 10 grand? A deposition? That's interesting. Oh, here we go. No charge to client. All redacted. Receipt of client emails and closing blank. All redacted. Meet with client and fiance here in office to discuss. Look at these redactions. Receipt of various documents from clients and YouTube videos redacted. Further review of all to formulate strategy for client. Receipt of email from Ty Beard at Beard Harris. Redacted. 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 No charges on these. They're not billing. They're not claiming them as part of the billing, but what are they? What are these? It's redacted here. Receipt from email from Ty Beard advising him to let him know if we ever accept service. Redacted. What's that? Redacted. No charge to client. Receipt and review of emails from clients. Redacted. Redacted. Brief telephone call with client regarding redacted. Who's your client, Casey? Receipt of email from redacted. Receipt and review of contract for Kamehakan. Response to Ron Toya email redacted. Finish review of the agreement. Note redacted. Now this might be redactable because this might just, as a note, a lawyer's thoughts and impressions and case notes or whatever, that's work product privilege. So that might be redactable. Telephone call with client to discuss redacted. Everything redacted. Receipt of email from Ron Toye redacted. Redacted. They're asking to pay for all of this stuff. This is something to remember. That they're asking, look, I did work on the case. I won't tell you what it is. Pay me $275 or more, actually, at this point. I think he was making more at Kessler Collins. Telephone call with client discussing redacted. Review and receipt of email. Oh, all redacted. Review and receipt of email from Monica Rial, redacted. Review recent video, redacted. Oh, Casey! Buddy, you don't have to redact my videos. Aw. Only an hour and 20 minutes, though. Slacker. What is he doing? Watch the whole thing, you coward. Let's see. Which video? Because maybe it was one of the short ones, and why do you get an hour and why do you get an hour? Maybe it's just like the 15 or 20 minute ones. Let's see. Prepare for client meeting with litigation strategy plan. Meeting with Mr. Eric and Mr. Barbieri to discuss blank. Meetings with Mr. Eric to discuss anti-slap motion strategy, redacted. Receipt of emails from clients from last night. Review additional interest and tube. I don't know what tube videos posted about the lawsuit. Continue following up on witnesses and prepare requests to depose Vic Mignogna. Redacted. Follow up with contacting redacted to discuss conversation. Redacted. Ooh, there's an in there. Prepare updates to litigation plan, including budget with estimated costs. Redacted. Correspondence to opposing counsel. Redacted. This is redacted. Let's see. Receipt of emails from client enclosing additional material to collect online. Communicate with representative from pagevault.com regarding recent quote to gather internet material. So their current fees. $64,484. Less advance applied. $31,101.96. Meeting with blank. Discuss anti-slap motion. Telephone conference with client and blank. Who's blank? Who are all these people? Blank. Communication with clients regarding blank. Blank. Conduct public records research on Manana. Phone calls with just blank. Phone calls with blank. Review and blank. Coordinate with clients regarding blank. 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 Receipt of additional tweets released by Nick Rekieta. These are Ron's. I don't think those were provided in his discovery. Blank. Receipt of blank from clients. Call Ron, Toye, and Monica. Blank. And file a motion to compel their deposition response to their motion. Download tweets and review posts from Rekieta Law. Good job. Sorry, Andrea. Sorry. Phone call with Michelle Specht. Conduct research on Rekieta tweets and videos. Conference call to discuss motion to quash. This poor chick, Andrea, you had to watch all of these videos? Oh my God. Status of case. Blank. Communications with clients about discovery requests. Blank. Phone call with blank. Phone call to discuss motion to dismiss with blank. Phone call with Mr. Johnson. Meeting with Mr. Eric. Communications with opposing counsel about extending anti-slap. Driving revise. Got blank. Blank. Phone call with blank. Statement. I mean, you guys see the problem with this, right? What is this stuff? What is the blank? What are blank? Review witness statements blank. Revise blank. Assist with discovery production. Assist with page vault. Are you assisting with page vault and video captures? Phone calls with Ms. Rial and Mr. Toye about blank. Interview with blank. Review emails provided by client blank. Why is their client name blacked out? Who's your client? Who's your client? Client's Rial and Toye, right? You're Kessler Collins. Isn't your client Rial and Toye? Who's your client? Communications with blank. Assist with deposition prep. What depot prep? Must be in-house depot prep. Phone call with Monica Rial. She did say she got a phone call. Phone calls with who? Deposition with Vic. Phone calls with Mr. Rial and Mr. Eric. Phone calls with blank. Complete blank here. Transcripts and exhibits from the deposition of Vic Mignogna to the share file repository. Shared with co-counsel in preparation for motion to dismiss. Blank. Communications with counsel and client regarding deposition releases. Blank. Phone call with Michelle Specht. Communications to coordinate affidavits. Draft corrections to Faisal Ahmed's affidavit. Corrections? Wait a minute. What are the corrections to Faisal Ahmed's affidavits? Draft affidavit. Draft affidavit. Who wrote them? Andrea wrote them. They're their words, though. They're their words. Redacted entirely. 3 hours. Just remember, guys, that 3 hours of Andrea's time is like roughly $850. Meeting to discuss case strategy. Revise blank. Phone call with Jimmy McManus. To discuss witness affidavit. Attend meeting with Rial blank. T. Phone conference to discuss blank. Communications with witnesses and witness statements. Phone call with blank. Blank. blank, blank. Collection of YouTube channel. Oh, man. Page Vault, you archived my stuff. Let's see. Mobile notary. Mobile notary. Just blank. Just completely blank. Again. They blanked out the amounts on these two. What? How much were they? This is a 4-figure amount. It's redacted. Oh my gosh. Let's see. Mobile notary for Teresa Yost and Elizabeth Yost. Let's see. Court reporter costs. Oh, here's a check. Here's all this stuff. Namrek Isto says, Nick, after seeing this, if I was a judge, I would say any page with even one redaction will not be factored in the costs the plaintiff's owed. Either unredact everything or accept $1,000 for wasting my time. Brian Dewig says, all your blank are belong to us. Yeah. Special delivery. Sorry. These are the mobile notaries. Who cares about this? Let's get to the real interesting question here. What do we have? Here's all the Page Vault stuff. Exhibit D. What is this? What is... What is this? Huh. Let's go up and see what Exhibit D is. Hold on. It's going to be in Casey's... Oops. Casey's affidavit here. Casey Eric. Exhibit D. 6. Let's see. Since I joined Cowles and Thompson PC, the total amount of reasonable fees and expenses incurred by defendants through dismissal is $25,932.50. This amount reflects 94.3 hours times $275 per hour plus $118.76 in expenses. See Exhibit D and E. Okay. Back to Exhibit D. So here's Exhibit D, since Casey Eric joined Cowles and Thompson. For more redactions. Does anybody notice anything about this page that's weird? There's a really weird thing on this page. See if you guys see. Date 6/18/2019. Client number 11637. Client name Funimation. That's weird. That's not John Volney's billing. Hmm. Let's see. What's really interesting here? 6/26/2019. Attend deposition of plaintiffs and clients in preparation for same. So, client name, Funimation. Prior to depositions, Casey Eric at the depositions. Did Ron lie under oath? Did Monica lie under oath? Huh. Weren't they asked if anybody else was directly or indirectly paying for their legal representation? Client Funimation. Why would Casey Eric write that the client was Funimation? Surely Ron and Monica are the client, right? Like, that's the client. I mean, this isn't a theory, right? Like, Casey's in charge of his own billing. Why on earth would he write client name Funimation? That's weird, fam. That's real weird. Well, I mean, I meant it was someone else, though. I mean, I meant it wasn't them. I meant it was. Why does your billing software say your client is Funimation? It's only all of it, though. Only all of the pages say Funimation. Who's your client? Exhibit E. Cost report. Cost report. Funimation. Mignana versus Funimation. Oh, you guys can't see that as well because it's way over to the left. Here we go. Kind of like Monica. Here. See. Cost report. Funimation for Mignana versus Funimation. Man, I wonder if the plaintiff might have issue with some of this billing. So anyway, I mean, I wanted to point that out. Now that I know that the plaintiff is actually really going through the billing, I will not take credit for seeing this. I had not combed through the billing entirely, and someone, I won't say who, someone sent me this and said, "Hey, what do you make of this?" And I was like, whoa, that's a problem. That's a big problem, actually. Because let's think about this. You're going to argue for attorney's fees and costs but it sure looks like your client may have lied under oath when directly asked about those attorney's fees and costs. And the lawyer who did it, the lawyer who's billing it is Casey Eric. Does anybody remember who was Ron's attorney for the deposition? Lemoyne was there for Big's deposition. Who was Ron's lawyer and Monica's lawyer at deposition? Wasn't Jay Sean. If your client is lying under oath and you know it, you have a duty not to allow that to happen. Very interesting. Very interesting. Very interesting questions for some of the parties involved. Gay and Still at Large says, is talking about Muppets effing your way of trying to get Linkara to stop hating you? Who's Linkara? If so, I suggest adding the green M&M into the mix and a black man named Tyrone. Also call him a dirty cockslut. He's into that. Who's Linkara? And does Linkara who? Does he hate me? Linkara, I don't know you, fam. I'm not that into you, girl. He's a Channel Awesome thing, right? Oh my goodness. Phipps Tedora. Oh gosh. I've heard the name Linkara. I know literally. These are all nobodies to me. I don't know who they are. Oh, is that Iron Liz's ex? Oh God. Okay. Eat me, Kirby! Eat it hard! Okay. Let's get serious. Oh no. Oh no. Okay. So that's what I've got on the Vic case, guys. That's what I've got. It looks like plaintiff's fighting back. I mean, there might be a reason, like a really freaking good reason to do so. First of all, the bills are padded heavier than Monica's bra. She's got those fat pancakes hanging there. The second thing is we got a serious issue with Casey's billing here. And we have got a serious issue with Casey Eric's billing. That's Oh goodness. So they're gonna fight that, apparently. That's what the reminder, this all started with the this motion to continue hearing, and because let's see. The myriad of objectionable there. Let me criticize you. This is Ryan Sellers. Ryan, it's just myriad objectionable time entries, not myriad of. It's a little redundant. You can just say myriad objectionable time entries. It's just the English major in me, buddy. I'm sorry. I hope to meet you and shake your hand someday. You're probably a cool dude. But yeah, get rid of the of there. Just clean it up a bit. That's great. So that's that's where we are here. I see a Meyer versus Wade request in the chat. Guys, they have not filed, the court has not ruled on jurisdiction yet. I'm still waiting. I check every day except for Saturdays. Although I did check today only because I didn't check yesterday. I check every day, every weekday that the court is open or whatever. I check to see if there is a filing. And it cost me 30 cents. 30 cents a pop, which I am billing to Mark Wade. 30 cents a day to check and see if there's an updated jurisdictional ruling on Pacer. There has not been one yet. So as soon as I know, I'm begging on Meyer versus Wade to have a ruling. I want to see that case advance. I want to see what happens. I want to make fun of Mark Zaid, the alleged pedo, and weird whistleblower attorney. Oh God, I want to go back to that. That boy's in the news. I want to make fun of him more. Hey, Mark Levin. I heard you talking about Zaid the other day. I happened to be driving my father-in-law's car. I stopped listening to your show a long time ago, buddy. It's not personal. It's not personal. I just don't have time to listen to anything anymore since I don't drive as much. But I was driving my father-in-law's car. Patriot Radio or whatever was on. And Mark Levin was on talking about Mark Zaid. Listen, back in 2017, he called it a coup. The coup is starting. I didn't even know the extent of it. Mark Levin, buddy, I would love to red pill you on Mark. Mark rhymes with Randy Quaid Zaid, okay? I would love to talk to you about it. It'd be the funniest thing in the world. Plus, I think you're hilarious. You get almost as angry as I do. And I want to know what my future looks like with blood pressure medication. But that being said, I would love to talk to you about Mark Zaid and Mark Zaid's personal friends threatening to have me murdered. Mark Zaid being okay with that. Mark Zaid lying about me publicly, and also Mark Zaid being just publicly BTFO'd by a rural bumpkin attorney in Minnesota. So I would love to do that, buddy. You have no idea the extent. Get out of here. There we go. Okay. Let's let's go on. I've got some, oh my God. What is this? Go. Here we go. Thank you, mods, for dealing with the insufferable spam from the weirdo. Just talk in English and say it one time. We're okay with it, buddy. You could say what you want. Just say it once in English. Or once in Chinese or whatever moonrune you're using. I don't care. Nova Zero says, well, Nick, that's because Monica and Ron are employees of Funimation. No, that's ridiculous. Absolutely ridiculous. So English, mother. Do you speak it? Where's Drexel when I need him? All right, let's go. I've got some feel good stories here that I wanted to get into. Let me get them queued up. These are good. There's some good times. I hope you guys like feel good stories. But that is the Vic stuff I've got for today. Let's see. What do we have? Oh, let's do that one. Hold on. Oh, here we go. Are you all ready? This one's a little bit old. This one's from October, and I hate this article. Might need Mark Levin's blood pressure pills now. I'm just making sure. Thought I had another one. I'm going to take a brief peek at this one. Let me see what we got here. I'll find the best picture to open this one with. I want the transition picture to be good. I want you guys to transition from looking at my face to looking at something, you know, that's at least as good as looking at me. There we go. There's Taylor Swift. No, I don't need the blood pressure meds yet, Jason, but if I keep reading the internet and being pissed off, I'm going to. So here's Taylor Swift being licked by two gay guys. Let's not pretend that any dancers on Taylor's tour or anything heterosexual. Taylor Swift is involved in some stuff here. I don't know what else to do. Oh, T-Swizz. Why you lying, girl? Now, brief, you know, you got to report your biases. I love Taylor Swift. Well, I don't like her new music so much. I like her older stuff. I really do enjoy it. If you catch me driving down the street, probably see me jamming out to some T-Swizzle, which is fine. No shame in that. I mean, there is, but I don't take any shame in anything. But I'm not a fan of what Taylor's doing right now. I'm laughing a little bit at Taylor and being like the richest performing artist on earth, and then losing the rights to her own music. But she's got some problems here. She's got some real problems. This is a weird story. I'm going to cover this in a short video more fully. I want to research it and figure out if there are two sides to this argument. As far as I can tell, there's not. One looks like Taylor is either lying or her counsel is lying to her. But she is doing this. Oh, man. Yes, my account is suspended. I know. Otherwise, I'd talk to her person. Just kidding. Here we go. You can make fun of how Taylor Swift got published all you want. She's the #1 money earning recording artist currently. I mean, it's hard to argue with that. Like, that's whatever you think of her music, somebody likes it. A lot of people do. But that's not important here. So let's read through her tweets. I gotta bring it down. Guys, it's been announced recently that the American Music Awards will be honoring me with the Artist of the Decade award at this year's ceremony. I don't know about that, but okay, whatever. I don't trust award shows anyway. I've been planning to perform a medley of my hits throughout the decade on that show. Scott Rekieta and a guy whose name is unironically Scooter have now said that I'm not allowed to perform my old songs on television because they claim, that would be re-recording my music before I'm allowed to next year. So this was part of their deal, apparently, in their acquisition of Big Machine Records and all of the rights to her music. They said you can re-record your own music in 2020. Additionally, and this isn't the way I had planned on telling you this news, sure, Netflix has created a documentary about my life. You're like 26. Why? For the past few years. Scott and Scooter have declined to the use of my older music or performance footage for this project, even though there is no mention of either of them or Big Machine Records anywhere in the film. Well, that doesn't really matter, does it, Pumpkin? They don't have the rights to their names being mentioned, they have the rights to the music. They have the rights you should have had. Why didn't you have them? You have more money than Jesus. These kids, man, these damn comic kids not understanding intellectual property rights. She has a team of lawyers who she pays infinity money to trademark like words. And she didn't realize that her music was up for grabs. Like, are we supposed to believe that? I just thought everybody loved me and no one would be interested in $1 billion worth of intellectual property. But they all do this, right? They all do this. Anyway. But yeah, they can do that. The owners of Big Machine Records can actually refuse to allow licensure of the music to Netflix for a documentary. That's okay. It doesn't matter if you mention them or Big Machine Records in the documentary. They could just refuse to license the rights to the songs that they just paid a whole lot of money for. How much did that cost? Let's see. Hold on. Big Scooter Braun buys Big Machine Records. Let's see how much this was. $300 million. He got it for a steal, if you ask me. That's pretty funny. Because he gets the Big Machine label and Taylor Swift's catalog for over $300 million. So somewhere between 3 and 350 probably, or maybe 3 and 4. So there you go. Oh man, I gotta go hang out with these guys. Look at the whiskey cabinet back here. T-Mobile, get off my browser, bro. But yeah, look at that. That's a Scotch shelf. We got up there. We got some good stuff. We got some is that Elijah Craig here in the middle? Some Jack Daniels. Well, that can be forgiven. This is Scotch. This might be a Glenlivet or a Balmore. It's a shame. They got a Johnny Blue. Or yeah, that looks like a Johnny Blue right there. That's at their private residence. Or one of their private residences. Who cares? Okay, so over $300 million, they get Taylor Swift's entire catalog, which is probably going to only grow in value. So good job. And the licensing agreements are likely lucrative. Either way, I thought they would have paid more, frankly. I mean, she makes something like $100 million a year. The reason I bring this up is because they not only bought Taylor's catalog, they bought they acquired an entire record label for that amount. So it's not just her catalog, it's also the label, which is the name Big Machine Records, which produces Taylor Swift. That's value in and of itself. That is inherent value that acquires all their distribution contacts, all of the goodwill that's been built up between them and other entities in the recording industry. So no, I don't use AdBlock. Why would I use AdBlock? AdBlock is for thieves. Thieves from Google, and Google is great. So here we go. Scott Borchetta told my team that they'll allow me to use my music only if I do these things. Now, the way she's going to present this is like, this is unfair, but this is how deals are done. A contract or an agreement between two parties requires the forfeiture of some legal right. Okay? I give up my legal right, you give up your legal right. Scott has said, you can use your music if you give up your legal right to this. And notice something that's happened here. She's conflated two issues. And we don't know what she's talking about down here. It's an open question of whether or not Taylor knows what she's talking about down here. Is Scott Borchetta talking about the AMA, the American Music Awards live performance? Or is Scott Borchetta talking about the Netflix documentary? Which one? We don't actually know. Allow me to use my music only if I do these things. If I agree to not re-record copycat versions of my songs next year, which is some things I'm both legally allowed to do and looking forward to. Yes, that's how agreements work. That's how agreements work. And also told my team that I need to stop talking about him and Scooter Braun. Why? Here's why. If you look, can I show you this easily? See down at the bottom? Can you see this? This has 875,000 likes. Taylor Swift makes a post on Twitter and 1 million people see it. Okay. Her disparagement has some value to them. Her talking bad about Scooter Braun and Mr. Borchetta is she doesn't want them, they don't want her talking about them because she has a huge audience and her very name carries influence in the industry. So stop talking about us. It's not about us, it's about your music catalog. So, but that's what you do. We'll make this agreement. You can use your music here, but you can't use it here. And you got to stop talking about us. If you don't agree to it, you don't agree to it. Fine. I feel very strongly that sharing what is happening to me could change the awareness levels for other artists and potentially help them avoid a similar fate. This message being sent to me is very clear. Basically, be a good little girl and shut up or you'll be punished. No. It's actually the opposite message, Taylor. It says, if you want to do this thing that you don't have a right to do, you need to give us what we want in return. That's it. This is illegal. This is how these agreements work out all the time. You want to do this. We have the rights. Give us something of value and we'll let you do this thing. This is wrong. Neither of these men had a hand in the writing of those songs. No, but one of them paid $300 million for it. And you don't have the rights to it because you're dumb. You're dumb. You could have... At any time, Taylor Swift could have negotiated for the rights to her own catalog. At any time. She has the money. She has the income. She has the clout. She could get private investing friends. There's no way. I mean, $300 million. Taylor Swift could sign a fashion deal for $300 million. With Target or something. Right? Like, let's be real. Taylor Swift branding on just about anything is easily worth $300 million over 10 years. No problem. Reminder that Clear Channel's contract with Rush Limbaugh for 10 years is $400 million. And Taylor Swift is a much bigger draw than a Rush Limbaugh on the money front. She just is. Love Rush. But this is someone who has broad appeal to a huge audience with tons of disposable income. Okay. They did nothing to create the relationship I have with my fans. That's true. This isn't about that. So this is where I'm asking for your help. Look at this. Look at this. I want to know if Monica Rial or Jamie Markey have supported this. This is Taylor Swift doing targeted harassment. By the way, Twitter, hello, at Twitter support. Taylor Swift is targeting harassment against Scott Borchetta and Scooter Braun, using her massive platform to draw ire against these gentlemen. Please let Scott Borchetta and Scooter Braun know how you feel about this. Scooter also manages several artists who I really believe care about other artists and their work. Please ask them for help with this. I'm hoping that maybe they can talk some sense into the men who are exercising tyrannical control over someone who just wants to play the music she wrote. Taylor, you were compensated handsomely by the distribution model created by Big Machine Records. You can't ignore that. Lots of people write lots of music. Not lots of people make $100 million by having access to a distribution mechanism of a major record label. I'm especially asking for help from the Carlyle Group, who put up money for the sale of my music to these two men. I just want to be able to perform my own music. It's not yours anymore. I'm sorry. I'm sorry. This is the chick, mind you, who was championing artists' rights for a couple years, like against Spotify and stuff like that, prior to this happening. She has lawyers who have told her this. That's it. I've tried to work this out privately through my team, but have not been able to resolve anything. And by the way, her lawyers are brilliant for this move. Taylor, how many Twitter followers do you have? Like 50 million? Put pressure on them. Public pressure is great. Right now, my performance at the AMAs, the Netflix documentary, and any other recorded events I'm planning to play until November of 2020 are a question mark. I love you guys, and I thought you should know what's been going on. Taylor. All right. How many followers does T-Swizzle have? 85 million people. Just asking for help from 85 million people. Look, she's got the massive help from like Perez. The Perez Hilton. Would my Twitter account be suspended if I share Scooter's phone number or email address? Guys, look at this. Look at these people running rampant around Twitter's terms of service is targeted harassment. Tanash says, F that, we're with you. Let's see. Mark Dice. I build some furniture and then sell it to someone else like you did your music, then I don't cry about it when the new owner won't let me use it anymore. Oh, that didn't get it got a couple likes. Songwriters rarely sell their songs. When you make a deal with a publisher, record label, or artist to record your song, it's usually the form of a contract or license. Sometimes the publisher will use the words work for hire. Yeah, no. Here's an idea. What if other artists perform your early songs in the first half of the performance paying tribute to you? Mechanical license already granted. She can mechanical license it herself. Anyway. Oh, Candace Owens calling her out. Toxic feminism. Look at everybody rushing to... I love this. This is the clout chase for real, y'all. This is the real... The Twitter clout chase is amazing. This guy, 1,700 followers, but he's got 16,000 hearts. He probably got like 500 followers from this post. It's a race. It's a race from when very popular people drop this stuff. But anyway, to post top. You want those top results. Top results. Perez Hilton probably has an auto monitor for Taylor Swift and can stop doing whatever he's doing to... Gross. Anyway, I bring this up because the Biebs... Look at the Biebs. Look at this picture they picked of Bieber. Oh, God. Embarrassing. Embarrassing as all get up. He dropped this on his Instagram. What does this say? Taylor Swift, free to play all her hits during AMAs. Big Machine can't stop her. So yeah, this TMZ reporting. Now, the label tells us she's dead wrong. Taylor can perform her entire catalog if she wants. Big Machine exec tells TMZ Taylor Swift can 100% perform all of her catalog. Why are you lying, Taylor? Past and present on the AMAs. The official adds, Big Machine has no issue with her performance going out on the live broadcast because it recognizes it doesn't have the right to block her. Official says our confusion with her statement is that we have no legal right to stop this and have never tried. She and her team both know this. So what's she flexing on? AMAs or Netflix? AMAs or Netflix? Fact is, Big Machine is correct. Labels can't block artists from performing any songs. There's others live since the AMAs are airing live. Have at it, Taylor. Okay, I'm going to get rid of the BuzzFeed news there. Gross. What do we got? Where's the... Didn't I have... I thought I had another window up, but maybe I didn't. I guess not. Hold on. I'll pull up the other things here. Where was it? Oh, this one. There was something else I wanted to pull up. Oh, that one's not as interesting. We'll pull this one up in just a second. But yeah, so there is an exception to copyright over live performances. Now the question is, there's a real question here. This is not as... They're making it sound pretty clear-cut, but the AMAs are not just... They're live, but they're not just live, right? They're recorded and broadcast across the planet here. So is it a recording? Maybe. Is it a recording in violation of rights? I'm not sure. I got to do a little more research here. But first of all, I was actually ready to be on board with that until TMZ agreed with it. Once TMZ agreed with it, I'm like, wait a minute. I trust TMZ to be stupid. So I'm not quite sure that they're correct. So I do plan on releasing a full short video about that. Because I got to do my own clout chase, right? I got to get... The grift is real here, y'all. The grift is real. The grift is real. So I got to clout chase T-Swizz a little bit and put out a video about that. But you know, it's not as clear cut, I don't think, as they're making it out to be. And if it is, think about the ramifications, right? If it is, I can do anything live on YouTube as a live performance, right? Like that's what they're saying. Well, it's a live performance, so you can do anything. So that means I can read full books. I can watch movies. No, I can't watch movies. I can do a live performance. I can live sing any song. YouTube can't do anything about it. That doesn't sound entirely accurate. So we're going to talk about that. We'll be doing some research because I have some great ideas for Racket's bedtime stories where I would love to read like 40K short stories or whatever. I think that'd be fun. Just do it live and have some time. But I don't think that that's true. But anyway, so that's you know, that's Taylor Swift. Here's the... Oh, sorry, that's the Vic GoFundMe. Let's update it. We've got $261,367. Thank you to Ramon Franco and Rodrigo Diaz. Thank you very much for that. All right, here you go, guys. This is The Atlantic, October 28th, 2019. This is a long... It's not that long of an article. It's kind of a long article. Oh boy. Oh boy. Are y'all ready for this? Paint your chest like zombie unicorn. I don't know what low-res picture they picked here. Like, look, it's a Where's Waldo. What is it? What is this picture? All right. Love the ads. of the ads. Oh, I got to make an announcement. We have the first official Rekieta Law intervenes. Rekieta Law, the YouTube channel, intervenes in people's lives, hopefully for the better. We have 2 members of this audience who just got engaged today. So my big shout out to Turbo Neil Breen and his new fiance Books Games Pottery. Both Discord friends and both people I have met in person. Wonderful couple, and I'm really excited for them. So congratulations to Books and Turbo Neil Breen. You guys are fantastic. Really happy to hear about it. Really excited for that. So that's wonderful. Oh, I was gonna do a Ridge Wallet thing. I guess I should do a Ridge Wallet thing too, real quick. I have a contractual obligation to do Ridge Wallet sponsorships. So let me remove some doxing cards from here. This is okay. This is fine. This is fine. That one's not, and those aren't. All right. Okay. We've got a real quick shout out to our friends over at ridgewallet.com, bringing you here we go, ridge.com/for the fans. This is the Ridge Wallet. So Ridge is the first and so far sole sponsor of the show. They are not the first people to ask, but they are the first people I said, hey, yeah, I actually like your stuff. I think it's pretty cool. And I think it'd be great if we tried out a sponsorship deal. And we did. And the first one went really well. You guys were very receptive to it. So they said, let's do another one. Let's see how it goes. So this is the Ridge Carbon Steel Wallet. It's got this cool like thatched pattern. It weighs like nothing. The heaviest part of it is actually the money clip. Look at that. Big spender dollars in the money clip this time. This thing is as big as a credit card. That's it. I prefer the money clip. My old Ridge wallet had the money strap. If you want to carry any cash, get the clip. Clip is great. Strap is, but I wouldn't do the strap personally for cash. If you like cash at all, money clip. They sell other things. They sell cell phone cases, backpacks, knives. I like the wallet. It's got this little notch here. You just push it up, and then you got your Supreme Court license card right there. You can fan out your cards or whatever, and you grab the ones that you want for whatever you need. It keeps everything small in your pocket, and they're great. I don't know how else to say it. They're cool. If you go to ridge.com/for-the-fans and use the For the Fans promo code, you'll get like 10% off. So thank you so much to Ridge for sponsoring this very short segment in a long live stream. I use it every day. I really do. It's a good product. If you want one, go buy one. If you don't. But if you're looking for a new wallet, they are great. The carbon fiber ones are kind of pricey. Don't get me wrong. I don't make light of it. They're like the titanium ones and the steel ones and aluminum ones are less expensive. There's some mumbo jumbo about these things being RFID shielding or whatever. I don't know. I don't have RFID cards. I just have the stupid chip cards. So I couldn't tell you if they're shielded or not, but they say they are. So there's that. Anyway, go check them out. Thanks, guys. Thanks. That was a word from our sponsor, Ridge Wallets. Ridge.com/for-the-fans. Check out your Ridge wallet. Okay, let's get back to this. Sorry about that. No, I'm not sorry. There's shameless grifting. Okay, Supreme Court briefs are not known for their colorful writing. That's not always true, actually. Have you ever heard of Antonin Scafflipping Leah? Readers are far more likely to encounter austere Latin legalisms than gripping personal narratives, because personal narratives aren't important in Supreme Court briefs. Oh, wait, they're talking about Supreme Court briefs, not opinions. Yet March for Our Lives chose to upend this norm in its amicus brief, a legal filing written by an interested outside party in the upcoming Supreme Court case, New York State Rifle and Pistol Association versus City of New York. If you're not familiar, I've talked about this case before. This is a case where in New York City, it is unlawful to take your gun anywhere other than from your home to the gun range and then back to your home. There are like 6 gun ranges in New York City. That means if you live in New York City and you have a firearm in your house, you are not allowed to take it to your other house anywhere else in the country. You're not allowed to take it to the grocery store. You're not allowed to take it anywhere other than to the gun range. I legitimately don't know what you're supposed to do if you move. Like to a new house or a different state or outside of the city. I don't know. Because I believe you'd have to destroy your gun and go buy a new one. And when confronted with this problem, the New York courts have actually said, well, buy a second gun for your second home. Too bad. Too bad. So the Supreme Court is hearing this because it is an arbitrary restriction on the Second Amendment. Although I believe the law has been appealed. They tried to roll the law back or scale it back to avoid the Supreme Court challenge, but it didn't work. The Supreme Court is hearing the case. They can stop open carry because they have licensed carry. They just don't really issue it. You need to stop at the range during the move. House to range, then range to new home. Loopholes, attaboy. But we're talking about like you can't, in theory, you can't go to the gas station on your way to the range or on your way home. You can't go to the grocery store. You can't stop and take in a movie. Nothing. Your trip has to be limited. The enforcement of this is, of course, difficult, but it is a law in New York City. Its brief, quote, presents the voices and stories of young people from Parkland, Florida, not New York, to South Central LA, who have been affected directly and indirectly by gun violence. The Supreme Court confirmed earlier this month that it would hear the case later this term, its first gun rights case in nearly a decade. Shame on you. The last one was the Chicago handgun ban in 2010. At issue is whether a New York City regulation that prevents licensed gun owners from transporting their firearms to second homes or gun ranges outside the city runs afoul of the Second Amendment. The stakes are high. The case offers the court's conservative wing a vehicle to further solidify legal barriers to firearm regulation. No, it doesn't. No, it doesn't. Not at all. This is a ridiculous regulation. This is an absolutely absurd regulation. And this regulation is based on a narrow reading of Heller, in which, in Heller, it was determined that basically you have a right to keep a handgun in your home for self-defense. Like, where else would you possibly keep a handgun than in your domicile? That is the most logical place, according to Scalia. And Scalia also threw in there, oh, and we want responsible gun owners, so they should have the ability to take their firearm to a place where they can train with the firearm to make sure they are competent in their self-defense. Ergo, we get permission to go to a gun range. Now, Scalia probably wasn't thinking that New York would limit it to literally house to gun range and back home. He was merely stating in his ruling that we should have an absolute right to have a firearm in our home and an absolute right to reasonable training with that firearm. Those things, that's the purpose of the self-defense portion of gun ownership. That's what Scalia is saying. Now, of course, New York, being full of idiots, has decided that that means those are the only places you can have a firearm, which is directly averse to the Constitution and actually directly averse to Scalia's entire argument about bearing arms. He's like, bear, carry on your person, have. You got to be able to have them. So, they didn't read Heller correctly, or they did read it correctly and flatly ignored it. That's the more likely outcome there. But that's how they're pulling this out, okay? But this has no legal barriers to firearm regulation. This isn't firearm regulation. This is idiocy regulation. You can have your gun here and here. Wait, what? What if you're going to a dangerous part of town? A decades-long project that has thus far been quite successful, in part due to the appeal of a unified constitutional narrative that pro-gun voices have invoked across both the legal and political spheres. Second Amendment, they say, protects an individual's right to gun ownership, a right rooted in deeply held notions of self-defense and individual reliance, and resistance to tyranny. They always leave that off, but that's where it actually lies, in resistance to tyranny. For decades, gun control advocates have left this narrative partially unanswered, offering depressing statistics but no compelling constitutional principle. They cannot afford to do so any longer. The March for Our Lives legal brief marks the beginning of a long-needed effort to offer a pro-gun control constitutional narrative. Are you ready for the part of the Constitution that says that you can't have guns? Because that's what they're talking about here. They're talking about the part of the Constitution that says you don't get to have your gun. All right? These include a collective understanding of self-defense. What is this? I smell communism. Where is it? Where is it? We must root it out. I smell the commies. Collective understanding of self-defense. This is anathema to the Constitution. As well as constitutional guarantees such as the right to public assembly and interests such as access to public education. So because people in public have been shot, or because people have shot up a school, they're going to argue that those rights, which are not being infringed on by government, are superior to the rights of gun ownership, which is being infringed on by government. Let's see. The point is that the right to bear arms is not the only constitutional commitment implicated in the guns debate, and the court ought to consider those other commitments as worth balancing with the right to bear arms, not as inherently subordinate to it. The problem is one of them involves state control, and the other one involves the individual actions of private citizens. Think about this. Think about the implications. Your right to free speech can go both ways, right? I guess if we can determine that the public has a right to free speech that trumps private people infringing upon it, like are we there? Is that where this is going to go? No, of course not. It's not where it's going to go, but that'd be the logical outcome. Well, if we have a collective understanding of free speech, then collectively we have a right to prevent individual actors, individual companies or persons from infringing upon our right to free speech with their speech or with their exercise of a constitutional right or whatever we want to say. We call our foundational legal text the Constitution because it constitutes our legal and political reality. No, not our political reality, just our legal one. The March for Our Lives brief is a reminder to the court that it cannot ignore the world it creates through its interpretation of the Second Amendment. Mind you, we live in probably the safest time in ever right now. You are safer now than literally ever from violence and gun violence. You're certainly safer than you were in 2006, in 1996. You safer now than at any time in the past 30 years, I believe. Okay. The brief asks the court to confront the consequences of the gun lobby's myopic approach. And it does so by bringing in the voices of young people whose lives have been upended by gun violence. This is what we in the philosophical world would call the appeal to emotion fallacy and a genetic fallacy. That an argument is somehow more meritorious because of its source and because of the emotional invocation. It recounts the narratives of Aaliyah Eastman, a Marjorie Stoneman Douglas student who saw blood pooling on the floor and a fellow student slumped against the wall dead. Jackson Middleman, a 6th grader who comforted the siblings of victims of the Sandy Hook shootings as they contemplated the loss of their 6-year-old brother. That's absolutely awful. It's hard for me to even read that. And Brooke Harrison, another Stoneman Douglas student who saw a lifelong friend shot at his desk and was forced to watch his body go limp. They're exploiting the children. Of fucking course they are. Of course they are. What better tool exploit than dead kids? Gun control advocates have long been making these sorts of arguments outside the legal spheres, at town halls and televised rallies. March for Our Lives brief takes its inspiration from these more dramatic arenas. Listen to how they word this. These are dead children. Takes its inspiration from these more dramatic arenas and brings that approach into the courtroom. This differs markedly from the legal arguments gun control advocates have used for decades. In courtrooms and law schools, advocates for regulations have traditionally made their case with more anodyne tools, textual analysis and statistics. You know, the tools that laws are made based on. The tools that law and legal argument exists under. You know, just those silly like textual analysis and just those pesky statistics. Just those, though. They have staked their claim on the textual reasoning that the word militia and the Second Amendment puts regulation of individual civilian gun ownership on the amendment scope. That's because they're idiots. It definitely doesn't. The militia was comprised of individuals who were expected to bring their own firearms. Regarding statistics, consider the brief filed by the American Academy of Pediatrics in the landmark 2008 gun rights case, District of Columbia versus Heller. Mind you, just 2 short years after the highest crime rate ever, which has only gone down from then, which cited more than 50 academic or governmental studies on gun violence and related issues. Just not John Lott's studies on gun violence or related issues. Conservative supporters of gun rights have long known that such approaches on their own are insufficient. Consider the amicus brief filed in Heller by then Texas Solicitor General, the Zodiac Killer, which cited figures such as George Mason and James Madison to paint a picture of an individual right that was core to the American idea. It was core. If you don't think it's core now, amend the Constitution. As Cruz wrote, the framers were understandably wary of standing armies and the powers of a potentially oppressive government. On this view, an individual right to bear arms ensures a citizenry capable of defending its rights by force when all other means have failed against any future oppression. This narrative does not just rely on dry points of law, just those dry points of law. It tells a story in which gun regulation is simply un-American and runs contrary to familiar values such as liberty, individualism, and opposition to tyranny and self-defense. They keep truncating the argument. Big Red Bear says, I disagree with your view on guns, but I am curious. What level of gun violence does it become unacceptable? Not asking this an appeal to emotion, but to find when do people on either side change their mind? Big Red Bear, this is actually a very sensible question, and I'd love to answer it right now. When they find it necessary to amend the Constitution and change the wording of the Second Amendment, they're afraid to do it. They're afraid to do it. They'll get unelected immediately. No matter what they claim about statistics and stuff like that, you go ahead and you, by law, through the Constitution, which they can do at any time from 1791 when the Constitution was signed through today. They could propose an amendment deleting the Second Amendment. That's all they have to do. They've never, ever done it. They won't even try. Even when we had a Democrat supermajority and a Democrat in the House and a Democrat majority in the Senate, they wouldn't even try because they'd be unelected the next cycle. And it would be a massive shift. A massive shift. But so they know the answer to this. The answer is when both sides feel it politically expedient to do so. The problem for the argument, the hypothetical that you propose, like that gun violence has gotten to a point where it would do that, is that gun violence has been decreasing for over a decade. It rose for 15 years from 1980 to 2006. And then it peaked, and then it's been decreasing for a decade. And we're at one of the safest points in American history, despite the mass shootings, despite them, and they are awful, don't get me wrong. And there may come a point where they're so frequent that they literally do drive people to demand a constitutional change. But until then, they're trying to do it through the courts, and no one's going to like it. So I hope that answers your question, but they've had the ability to do it forever and have never even tried. Okay. Gun control advocates need their own constitutional narrative, one that incorporates a broader conception of self-defense into its vision. Since Heller, the court has drawn a straight line connecting the broader constitutionally grounded right to self-defense to the more specific right to individual gun ownership. Heller is, by the way, every time I read Heller, I get more and more pissed off at Scalia because he further restricted gun ownership in stupid ways. But defense of oneself and one's family can be pursued in a variety of ways. What, like machetes? What are we, Jakarta? An individual right to gun ownership offers one path, deputizing all people to defend themselves with a firearm at their side. Gun regulation offers another such path to self-defense, one vastly more efficacious and preferred by the American public. This is not necessarily true, is actually undermined by a 2012 study funded by the Obama administration. I think it's a 2012 study funded by the Obama administration into gun violence, which found that the usage of guns in self-defense far outweighs the usages of guns in violence, in criminal violence. It represents a mode of preemptive self-defense whereby the state is tasked by its citizens with limited access to deadly force. Saying this is more efficacious and preferred is relying on statistics from other countries. And their cultural differences aside, the effectiveness of gun violence, of gun regulation in those countries and those cultures. Cultures in countries that are not rooted in freedom in the same way. Cultures in countries that have a vastly different demographic makeup. Cultures in countries that have different relationships with their own governments. And that don't have constitutions because they're run by parliaments. So, on this view, when we urge the government to enact universal background checks, which, by the way, I'm pretty sure that if you go back and look at every single mass shooting, because that's what they're talking about, right? Mass shootings. Every single case, a universal background check would not have solved the problem. Raise the legal age to purchase firearms from 18 to 21, which I also believe would not have solved any of the problems. Not a single. Do we know of any 18 to 21-year-old who legally purchased a firearm and then caused a mass shooting with that legally purchased firearm that they bought as an 18 to 21-year-old? I don't know of any. Maybe there is someone. Sandy Hook kid murdered his mom and took her gun. I don't know. Maybe the kid down in Florida was legally purchased a firearm. I don't know if that's true. That might be. The Florida kid may have legally purchased a firearm as like an 18 or 19-year-old. I don't remember. And used it to do his mass shooting. That may be the case. Other than that, and ban the sale of assault weapons. Which the question is, if you ban the sale of assault weapons, would you actually reduce the effectiveness of mass shootings? Many mass shootings are not used by assault or are not using assault weapons. Pistols, shotguns. Columbine was not assault weapons. The Aurora Theater was not an assault weapon. Sandy Hook was, although I'm not sure that an assault weapon was actually beneficial, if that makes sense, in accomplishing his goals. Could it have been done with a handgun? Maybe. I don't know. We are seeking to use the one that I can think of that is definitely a higher body count from an assault weapon would have been Las Vegas, which that's the one they don't talk about, right? Las Vegas shooting. We don't want to talk about the Las Vegas guy, but that's one where the advantages of an assault rifle in accuracy and range were definitely apparent. Other than that, I'm not so sure. Maybe the Pulse nightclub. Let's see. We are seeking to use the government's regulatory authority rather than say the arming of every school teacher to defend ourselves and our children. This misses a mark because there are 300 million guns that exist in this country. What are you going to do about that? That the gun rights movement has somehow managed to monopolize the constitutional mantle of self-defense isn't as impressive a PR feat as it is absurd. No, it isn't, because anybody who has had a gun and even drawn it in self-defense knows exactly why it exists. It's a force equalizer in self-defense. Women who have guns don't get raped as often. I don't know, like, what? It's a force equalizer. You take a 100-pound woman and you put her at a higher amount of lethality to a 300-pound muscle-bound man. That's crazy. Guns are the equalizer. They are the force equalizer all over the world. In addition to self-defense, other obvious rights and interests of constitutional magnitude are imperiled by gun violence and vindicated by regulation. The right to assembly is put at risk when a single shooter can rain bullets on a peaceful political protest. I mean, the right to assembly is not actually put at risk at all in that. I have to say it. This doesn't sound good, but that assembly is put at risk. The right to assembly overall, they're talking about a chilling effect imposed by the actions of an individual, not a state. Not a state. These are core constitutional issues that they need to overcome with this argument, and they're going to find it really hard to do. They know this is a losing argument, especially in this Supreme Court. And this is one of the reasons they're pretending Ginsburg is still alive. That's a joke. She's definitely still alive. Freedom of the press is undermined when published words can give way to mass murder, as occurred at the Capitol's Annapolis, Maryland office in 2018. No, it isn't. No, it isn't. Freedom of the press is the freedom to publish something without being jailed. There is no jailing involved in the publishers of speech when someone shoots them. And it is awful that people get shot. I don't know. This is the disingenuous nature of the argument. The fact that they're talking about, the reason it's an impressive PR feat is because we have to overcome the actual PR. Gun rights advocates have to overcome the actual public relations spin of trumpeting the dead. Other cherished constitutional interests, such as the freedom to vote or access to public education, is that a constitutional interest? Access to public education. I don't think that's actually a constitutional interest at all. Cannot be secured when mass shootings are a constant specter outside polling places or at the schoolhouse gate. They're not actually a constant specter at either place, except for what the media makes them. The overwhelming likelihood as a student in the United States, the 99.9% of students will not experience a mass shooting. It might be 99.99% of students will never experience a mass shooting. You're more likely to be struck by lightning than experience a mass shooting, I believe, is the comparison. It's not a constant specter. And polling places, oh my gosh. Polling places are actually, they're not, I can't even think of the last mass shooting at a polling place. But by the way, we regulated guns away from both of those places. Schools and polling places, there are no guns there. We regulated that. This is a key problem with their argument, right? Those are regulated. That's a real problem logically for your argument. You're asking for regulation of something where it is regulated. They made it illegal. A fundamental and this is to say nothing of the value of protecting life. Oh, I wonder what this person has written about abortion. A fundamental basis of the Constitution itself that is incompatible with an ever-expanding conception of the Second Amendment. This is ridiculous on its face. There is not an ever-expanding conception of the Second Amendment. From 1791 to today, the conception of the Second Amendment has been nothing but limited, starting in 1939 with U.S. v. Miller and continuing through D.C. versus Heller and whichever the Chicago case was. These are all extremely limited conceptions of the Second Amendment. A Second Amendment in 1791 federally guaranteed your right to ownership of a battleship, the greatest piece of military technology available. The cannons used in the Revolutionary War were borrowed from private owners. This is insane. The top weapons of the day, military-style assault murder factories of the day, were permitted under the Second Amendment in 1791, when the Constitution was ratified. To suggest that we have an expanding conception of the Second Amendment is absolutely ludicrous. Ludicrous in concept. Like, just on its face, this is flat out stupid. Nova Zero says, look, internet has told me that words are violence, so I'm more concerned with free speech. Oh, and what are the complications of traveling from New York with a gun to a gun range in, say, Hong Kong, asking for a friend? No, it's literally the 6 gun ranges in New York City that you're restricted to. Even when upholding gun regulations, American courts rarely, if ever, reference these counterbalancing constitutional values. It's because they're not constitutional values that are counterbalanced or even implicated by the individual right to gun ownership. Instead, regulation is presented in sterile, technocratic terms. This is not true. This is patently false. The author of this article is lying to your face. Regulation is presented deeply rooted in context exactly like this. Regulation of these weapons in Connecticut directly followed the Newtown shooting and were based in part on the tragedy of the loss of children's lives at Newtown. Period. Period, period, period. When they bring regulation, they have to bring statistics. And Oh my God, the regulators do nothing but bring favorable statistics about the deaths of people from gun violence. And they bring individual stories, and they bring letters and testimony from people who have lost loved ones or relatives, or even people they don't like, but they're going to pretend to for the whole purpose. They bring these heart-wrenching letters and they read them on the floor of Congress. This is either flat out stupidity or a direct lie from the Atlantic author, and they should be ashamed. They should be ashamed of lying about this. At best permissible, but never a constitutionally inspired imperative. They're not sterile technocratic terms. They're brought fully loaded in emotional anecdotal stories. How can courts do otherwise when they lack a narrative that locates these values at the heart of the constitutional debate over guns? They can't do it because there isn't a constitutional narrative in the way that you want there to be. JCF Data says, if Funimation is Kessler Collins' client, and Wick Phillips lists Kessler Collins and the primary client are Toya and Rial, to me looks like Funny hired JSL through Kessler Collins, and Funny is really WP/JSL's client. Need to disclose who paid. Yep. Killer Johnny says, does anyone know where Ginsburg was when Epstein was murdered? No. Constitutional narratives drawn from the contemporary world are admittedly a bit novel in today's legal arena because they're not effective argument. The whole idea, by the way, of Constitution, right? That the court... Reminder what they're doing here. They're not advocating a constitutional amendment to change reflecting the political realities of today. They're asking the court to consider a document drafted long ago that is intended to bind the actions of the government based on the writing, okay? They're asking the court to look at a document that is 250 years old that was specifically intended to bind the actions of the government going forward and to say, nope, you're restricted from doing this, and this, and this, and this until you change this document. You are restricted from this. Now they're asking the court to add a narrative drawn from the contemporary world and then modify the historical meaning of the text. This is anathema to the court's role, whatever it may have pretended it to be under judicial review. It's anathema. The idea is that the court is there to uphold the Constitution, not to take a contemporary narrative and insert it to a 250-year-old document. That's Congress's job to then go in and amend and ratify the amendment. That's what Congress is supposed to do. This is just basic misunderstanding of civics, the role of the court, the role of the Constitution itself. It's a constitution because it is our constitutional principles. It is the heart, the lifeblood, the structure of the legal order of the country. And to then have a court come in and change that Constitution based on a contemporary narrative is opposite of what we intended, opposite of what the founders intended. They gave us a mechanism to do this. Do it. Why won't you? They want to hold the power. This is in part the result of a decades-long effort by right-leaning gun advocates, lawyers and scholars to frame arguments that rely on anything but the Constitution's text and the original values recognized at the time of the founding is not constitutionally valid. That's because they're not. Their interpretive methodologies, aptly named textualism and originalism, and yours are named liberalism and interpretivism, deny constitutional imprimatur to rights and interests that cannot be identified in the Constitution's plain text. Nope, they're all identified in the Constitution's plain text or found in narratives premised on the writings of long dead men. Actually, all of our rights, all of them, even the ones that aren't specifically in there, are found in narratives, are found in the Constitution's plain text. They're the 9th and 10th Amendments. They're what you relied on for legalizing abortion. As as an abortion of a decision as Roe versus Wade is, even as Ginsburg admits, that's where they are. They're there. If you need to clarify or change it, do it. You have the tools. But it need not be this way. In the words of Supreme Court Justice Robert Jackson, constitutional interpretation that ignores its real-world implications, quote, will convert the Constitutional Bill of Rights into a suicide pact. Oh, do we have the... Hold on. Let's do a fact check. See. Terminiello v. Chicago, 1949. Mr. Douglas delivered the opinion of the court. What do we got here? Let's find... So Robert Jackson wrote it. Let's see. Well, let's change it to Jackson. Mr. Jackson and Mr. Justice Burton joined this dissent. Okay, so this is a dissenting opinion. All right. Let's take a look at this. Okay. Are we ready? Here's the synopsis of the case. Arthur Terminello was found guilty in the Municipal Court of Chicago of violating an ordinance of the city by making an improper noise or diversion tending to a breach of the peace, and he appealed directly to the Supreme Court of Illinois. Cause was transferred to the appellate court for the 3rd District by the Supreme Court. Judgment of conviction was affirmed by the appellate court. Judgment of the appellate court was affirmed by the Supreme Court of Illinois, and defendant brings cert. This was then reversed. So let's see what happened. I don't even care what Jackson says. Let's see what happens here. Let's see what this is a fun thing that journalists do. We're going to just take some words that we like and ignore the context they're in. Let's take a look. In a meeting which attracted considerable public attention, petitioner addressed a large audience in an auditorium outside of which was an angry and turbulent crowd protesting against the meeting. He condemned the conduct of the crowd outside and vigorously criticized various political and racial groups. Notwithstanding efforts of a cordon of police to maintain order, there were several disturbances in the crowd. Petitioner was charged with violation of an ordinance forbidding any breach of the peace. And the trial court instructed the jury that any misbehavior which stirs the public to anger, invites dispute, brings about a condition of unrest, or creates a disturbance violates the ordinance. Petitioner did not accept to that instruction, but he did maintain at all times that as applied to his conduct, the ordinance violated his right to free speech under the federal Constitution. At a public meeting, a guy stood up and said words, and they found him guilty, and Jackson dissented. Now let's see what Jackson has to say. Okay, Jackson dissenting. The court reverses this conviction by reiterating generalized approbations of freedom of speech with which, in the abstract, no one will disagree. Doubts as to their applicability are lulled by avoidance of more than passing reference to the circumstances of Terminello's speech and judging it as if he had spoken to persons as dispassionate and empty benches, or like a modern Demosthenes practicing his Philippics on a lonely seashore. Oh, dissents are great. Dissents are always great. But the local court that tried Terminello was not indulging in theory. It was dealing with a riot and with a speech that provoked a hostile mob and incited a friendly one and threatened violence between the two. When the trial judge instructed the jury that it might find Terminello guilty of inducing a breach of the peace if his behavior stirred the public to anger, invited dispute, brought about unrest, created disturbance, or molested peace and quiet by arousing alarm. He was not speaking of these as harmless or abstract conditions. He was addressing his words to the concrete behavior and specific consequences disclosed by the evidence. He was saying to the jury, in effect, that if this particular speech added fuel to the situation already so inflamed as to threaten to get beyond police control, could not be punished as inducing a breach of peace, because it can't. If he's not calling for violence, if he's not calling specifically for violence, he can't. Look, guys, if there are rowdy people there, you can't talk. Wait, what? What? When the light of the evidence not recited by the court is thrown upon the court's opinion, it discloses that underneath the little issue of Terminello and his $100 fine lurks some of the most far-reaching constitutional questions that can confront a people who value both liberty and order. This court seems to regard these as enemies of each other, and to be of the view that we must forego order to achieve liberty. Order? We will order you, right? It's okay. You will obey the orders. So it fixes its eyes on a conception of freedom of speech so rigid as to tolerate no concession to society's need for public order. Guys, your speech is just subject to the public's need for order. That's fine. That's fine. You know, why do you need your speech? What if the public reacts negatively to what you say? Well, then you've got to go to jail. An old proverb warns us to take heed lest we, quote, walk into a well from looking at the stars. To show why I think the court is in danger of doing just that, I must bring these deliberations down to earth by a long recital of facts. Terminiello advertised as a Catholic priest, but revealed at the trial to be under suspension by his bishop, was brought to Chicago from Birmingham, Alabama, to address a gathering that assembled in response to a call signed by Gerald L.K. Smith, which, among other things, said, "The same people who hate Father Coughlin hate Father Terminiello." Okay, so this is a racist, right? This is probably what's going on here. I'm gonna guess. They have persecuted him, hounded him, threatened him, but he has remained unaffected by their anti-Christian campaign against him. You will hear all sorts of reports concerning Father Terminiello, but remember that he is a priest in good standing and a fearless lover of Christ in America. The jury may have considered that this call attempted to capitalize the hatreds this man has stirred and foreshadowed, if it did not intend to invite the kind of demonstrations that followed. Terminiello's own testimony shows the conditions under which he spoke. So far as material, it follows. We got there, the meeting place, approximately 15 or 20 minutes past 8. The car stopped at the front entrance. There was a crowd of 300 or 400 congregated there, shouting and cursing and picketing. Quote, when we got there, the pickets were not marching. They were body to body and covered the sidewalk completely, some on the steps, so that we had to form a flying wedge to get through. Oh, they've seen the Mighty Ducks then. Police escorted us to the building, and I noticed 4 or 5 others there. They called us goddamn fascists, Nazis, ought to hang, the so-and-sos. When I entered the building, I heard the howls of the people outside. There were 4 or 5 plainclothes officers standing at the entrance to the stage and 3 or 4 at the entrance to the back door. The officers threatened that if they broke the door again, they would arrest them, and every time they opened the door a little to look out, something was thrown at the officers, including ice picks and rocks. A number of times the door was partly broken through. There were doors open this way, and they partly opened, and the officers looked out 2 or 3 times, and each time ice picks, stones, and bottles were thrown at the police at the door. I took my place on the stage. Before this, I was about 10 or 15 minutes in the body of the hall. Saw a number of windows broken by stones or missiles. I saw the back door being pushed open. Front door was broken, partly open after the doors were closed. There were about 7 people seated on the stage. Smith opened the meeting with prayer, the Pledge of Allegiance to the flag, and singing of America. There were other speakers who spoke before me, and before I spoke, I heard things happening in the hall and coming from the outside. I saw rocks being thrown through the windows, and that continued throughout at least the first half of the meeting, probably longer, and again attempts were made to force the front door. Rather, the front door was forced partly. The howling continued on outside. Cursing could be heard audibly in the hall at times. Police were rushing in and out of the front door, protecting the front door. There's a general commotion, all kinds of noises and violence, all from the outside. Between the time the first speaker spoke and I spoke, stones and bricks were thrown in all the time. Look at what this is the quote. This is the quote that the Atlantic article writer is saying. Your individual rights are subservient to the mob. This is no different, right? This guy's individual right to speak should be subject to people committing violence outside. Look, if there's violence outside, this guy can't speak. How can we allow him to speak if there's violence? That means the mob, a violent mob, shuts down all rights. Period. Under the Atlantic author's interpretation, that's what they're saying. Well, if we just have a violent mob, then there is no individual right. This is the opposite of the Constitution. Let's see. I started to speak about 35 or 40 minutes after the meeting started, a little later than 9 o'clock. Court below, in addition to this recital, heard other evidence that the crowd reached an estimated number of 1,500. Picket lines. That means, by the way, that Ben Shapiro, Ann Coulter, Milo, all those things justified. They shouldn't be allowed to speak. How could they have a right to speech? There's a mob there, an angry mob. Violence outside. Picket lines obstructed and interfered with access to the building. The crowd constituted a surging, howling mob, hurling epithets at those who would enter and trying to tear their clothes off. One young woman's coat was torn off, and she had to be assisted into the meeting by policemen. Those inside the hall could hear the loud noises and hear those on the outside yell fascists, Hitlers, and curse words like damn fascists. Bricks were thrown through the window panes before and during the speaking. About 28 windows were broken. The street was black with people on both sides for at least a block either way. Bottles, stink bombs, and brickbats were thrown. Police were unable to control the mob, which kept breaking the windows at the meeting hall, drowning out the speaker's voice at times and breaking in through the back door of the auditorium. About 17 of the group outside were arrested by the police. Knowing of this environment, Terminello made a long speech from the stenographic record, of which I omit relatively innocuous passages and add emphasis to what seems especially provocative. Uh-oh. Let's see what he had to say. I bet it's good. And by good, I mean it's probably awful because that's the speech you have to protect. You have to protect the speech you disagree with. Here we go. Father Terminello, quote, "Now I'm going to whisper my greetings to you, fellow Christians. I will interpret it. I said fellow Christians, and I suppose there's some of the scum got in by mistake. So I want to tell a story about the scum. And nothing I could say tonight could begin to express the contempt I have for the slimy scum that got in by mistake. The subject I want to talk to you tonight is about the attempt that is going on right outside this hall right tonight. The attempt that is going to destroy America by revolution. My friends, it is no longer true that it can't happen here. It is happening here, and it only depends upon you good people who are here tonight. Depends upon all of us together. As Mr. Smith said, the tide is changing. If you and I turn and run from that tide, we will all be drowned in this tidal wave of communism, which is going over the world. He's an anti-commie. The crowd is a bunch of commies. I didn't even see it coming. I thought it was going to be a race thing. How fucking perfect. How perfect. How perfect can it be that the Atlantic writer is siding with the communists violently mobbing to suppress the speech of an anti-communist? It couldn't possibly have happened in a funnier way. I legit thought that this guy was going to be like, we need to hang the, right? Like that this is going to be the same as Brandenburg versus Ohio, like the KKK guy having his right to speak. No, they're calling him a Nazi because he's anti-commie. Oh, this is great. This is great. I'm going to talk to you about the menace of communism, which is already accomplished in Russia, where from 8 to 15 million people were murdered in cold blood by their own countrymen. And millions more through Eastern Europe at the close of the war being murdered by these murderous Russians. Hurt being raped and sent into slavery. That is what they want for you, that howling mob outside. Fucking commies. Of course it's commies. I know I was told one time that my winter quarters were ready for me in Siberia. I was told that. Now I'm talking about the 57 varieties that we have in America. And we have 57 varieties of pinks and reds and pastel shades in this country. And all of it can be traced back to the 12 years we spent under the New Deal. FDR. Not Teddy, FDR. The F in FDR is fucking Commie Delano Roosevelt. Because that was the buildup for what is going on in the world today. This man is a regular freedom fighter. Now, Russia promised us we would go back to the official newspaper of Russia. Primarily, it was back about 1929. They quoted words of George E. Dimitrov, who at the time was the executive secretary of the Communist International. I only quote you this one passage. I could quote thousands of paragraphs for you. Let me quote you. Quote, the worldwide nature of our program is not mere talk, but an all-embracing, blood-soaked reality. That is what they want for us, a blood-soaked reality, but it was promised to us by the crystal gazers in Washington, and you know what I mean by the crystal gazers, I presume. First of all, we had Queen Eleanor, Mr. Smith said. Queen Eleanor is now one of the world's communists. She is one who said this. Imagine coming from the spouse of the former president of the United States. That's Eleanor Roosevelt he's talking about. For 12 long years, this is what she said. Quote, the war is but a step in the revolution. The war is but one step in the revolution, and we know who started the war. Then we have Henry Adolph Wallace, the 60 million job magician. You know, we only need 54 million jobs in America, and everyone would be working. He wants 60 million jobs because some of the bureaucrats want 2 jobs apiece. Here he is, what he says about revolution. We are in for a profound revolution. Those of us who realize the inevitableness of the revolution and are anxious that it can be a gradual and bloodless instead of somewhat bloody. Of course, if necessary, we will have it more bloody. Why do we think McCarthy was scared of commies in the government? I wonder why. I do the accent, but these are Americans. Oh, wait, should I do FDR's accent? And then Chief Justice Stone had this to say. A way has been found for the effective suppression of speeches and press and religion, despite constitutional guarantee from the Chief Justice of the United States. Now, my friends, they are planning another ruse. And if it ever happens to this country, God help America, they are going to try to put into Mr. Edgar Hoover's position a man by the name of George Schwarzwald. I think even those who are uneducated on so-called sedition charges, that the majority of the individuals in the department, that Christ-like men and women who realize today what is going on in this country, men who are in this audience today, want to know the names of these people before they are outside. They want to know the names, if any. Did you hear any tonight that you recognize? Most of them probably are imported. They're imported from Russia, certainly. If you know the names, please send them to me immediately. This is a long speech. Please says, my first live stream. Here's $20 for helping me through my graveyard shifts. Hey, thanks, buddy. I appreciate it. Welcome to the show. Didn't you ever read the Morgenthau plan for the starvation of little babies and pregnant women in Germany? Whatever could a child that is born have to do with Hitler or anyone else at the beginning of the war? Why should every child in Germany today not live to be more than 2 or 3 months of age? Because Morgenthau wants it that way, and so did FDR. You know who is behind it? When I tell you the story of a doctor in Akron, Ohio, he boasted to a friend of mine within the last few days while he was in the service of his country as a doctor. He and others of his kind made it a practice. Now, this was not only one man, made it a practice to amputate the limbs of every German they came in contact with whenever. They could get away with it, so they could never carry a gun. Imagine men of that caliber sworn to serve this beautiful country of ours. Why should we tolerate them? My friends, the moment someone reminded me of the plan to sterilize them. The nurses, they tell me they are going to inject diseases in them, syphilis and other diseases in everyone that came there, all of one race, all non-Christians. Now we are going to get threats of the people of Now we are going to get the threats of the people of Argentine, the people of Spain. We have now declared, according to our officials, to have declared Franco to have taken the place of Hitler. Franco was the savior of what was left of Europe. Now let me say I'm going to talk about, I almost said about the Jews. Of course, I would not want to say that. However, I'm going to talk about some Jews. He's not going to talk about the Jews, just some Jews. I hope that I'm a Christian minister. We must take a Christian attitude. I don't want you to go from this hall with hatred in your heart for any person, for no person. Now, this danger which we face, let us call them Zionist Jews, if you will. Let's call them atheistic, communistic Jewish or Zionist Jews. Let us not fear to condemn them. You remember the apostles when they went into the upper room after the death of the master. They went in there after locking the doors. They closed the windows. At this time, there was a very loud noise as if something was being thrown into the building. Don't be disturbed. That happened, by the way, while Mr. Gerald Smith was saying, "Our Father who art in heaven." Just then a rock went through the window. Do you wonder they were persecuted in other countries in the world? You know, I have always made a study of the sociology of mob reaction. It is exemplified out there. Remember that there has to be a leader to that mob. He is not out there. He is probably across the street looking out the window. There must be certain things, money, other things in order to have a successful mob action. There must be rhythm. There must be some to beat a cadence. Those mobs are chanting. That is the caveman's chant. They were trained to do it. They were trained this afternoon. They are being led. There will be violence. The judge highlighted there will be violence, indicating that the priest who's talking about the mob literally throwing bricks at cops knew there would be violence. 1949, guys. Sounds like today. Sounds like today. That is why I say to you men, don't you do it. Walk out of here dignified. The police will protect you. Put the women on the inside. Where there will be no hurt to them. Just walk. Don't stop and argue. They want to picket our meetings. They don't want us to picket their meetings. It is the same kind of tolerance. If we said there was a bed bug in bed, we don't care for you. Or if we looked under the bed and found a snake and said, I'm going to be tolerant and leave the snake there. We will not be tolerant of that mob out there. We are not going to be tolerant any longer. Notice he doesn't highlight the fact where the guy says, don't argue with them. Just keep walking. Don't fight with them. We're strong enough. We're not going to be tolerant of their smears any longer. We are going to stand up and dare them to smear us. He highlights that. Emphasis added here. So, my friends, since we spent much time tonight trying to quiet the howling mob, I'm going to bring my thoughts to a conclusion. And the conclusion is this. We must all be like the apostles before the coming of the Holy Ghost. We must not lock ourselves into an upper room for fear of the Jews. I speak of the communist Zionistic Jew, and those are not American Jews. Oh, they're fine then. They're good. This is before the creation of the state of Israel, I believe, right? That's 1952, 57. Israel is coming, but it's not there yet, right? So, but he's talking about non-American Jews. So it's okay. He's not all Jews. We don't want them here. We want them to go back where they came from. Okay, then we've got... So let's see. Mr. Smith says some words. Such was the speech. Evidence showed that it stirred the audience not only to cheer and applaud, but to expressions of immediate anger, unrest, and alarm. One called the speaker a goddamn liar who was taken out by the police. Another... I can't even read what he said. He said, another said that Jews, ninjas, and Catholics would have to be gotten rid of. Wow, the communists hated black people. Because this is a Catholic priest, right? One response was, yes, the Jews are all killers, murderers. If we don't kill them first, they will kill us. The anti-Jewish stories elicited exclamations of, oh, and isn't that terrible? And shouts of, yes, send the Jews back to Russia. Kill the Jews. Dirty K-words. and much more of ugly tenor. These are all quotes. This is not my words. These are quotes from a historical time. This is a specific and concrete kind of anger, unrest, and alarm, coupled with that of the mob outside, and that the trial court charged the jury might find to be a breach of peace induced by Terminiello. It's difficult to believe that this court is speaking of the same occasion, but is the only one involved in this litigation. Terminiello, of course, disclaims being a fascist. Doubtless many of the indoor audience were not consciously such. His speech, however, followed with fidelity that is more than coincidental, the pattern of European fascist leaders. I wonder if this guy is actually a Nazi. I have no idea. And can you trust what's written about him? Yeah, Sam DVX, they're from the audience he was addressing in the building, but also, he said some scum slipped in. And the one guy was clearly opposed to him, so who knows? Israel was May 1948. Okay, so Israel apparently had just been created. So this is interesting. The street mob, on the other hand, included some who deny being communists, but Terminiello testified and offered to prove that the demonstration was communist organized and communist led. He offered literature of left-wing organizations calling members to meet and mobilize for instructions as pickets and exhorting followers, quote, all out to fight fascist Smith. What's it sound like? This is shockingly similar, right? Speech, even speech you hate, must be protected. It must be protected. As this case declares a nationwide rule that disables local and state authorities from punishing conduct which produces conflicts of this kind. It's because it's speech. It's political speech, specifically the type of speech, speaking out against the government and against specific government officials and government policies. That's exactly what we need to protect the most. It is unrealistic not to take account of the nature, methods, and objectives of the forces involved. This was not an isolated, spontaneous, and unintended collision of political, racial, or ideological adversaries. It was a local manifestation of a worldwide and standing conflict between two organized groups of revolutionary fanatics, each of which has imported to this country the strong-arm technique developed in the struggle by which their kind has devastated Europe. But one group was peacefully assembled and the other wasn't. This is the problem. A non-peaceful assembly doesn't get to shut down a peaceful one. Increasingly, American cities have to cope with it. One faction organizes a mass meeting. The other organizes pickets to harass it. Each organizes squads to counteract the other's pickets. Sound like today? This is the Battle of Berkeley. Parade is met with counter parade. Each of these mass demonstrations has the potentiality, and more than a few, the purpose of disorder and violence. This technique appeals not to reason, but to fears and mob spirit. Each is a show of force designed to bully adversaries and to overawe the indifferent. We need not resort to speculation as to the purpose for which these tactics are calculated, nor is their consequences. Recent European history demonstrates both. Hitler summed up the strategy of the mass demonstration as used by both fascism and communism. We should not work in secret conventicles, but in mighty mass demonstrations. Wait, that's like a Scottish German. That's weird. It is not by dagger and poison or pistol that the road can be cleared for the movement, but by the conquest of the streets. We must teach the Marxists that the future master of the streets is National Socialism, just as it will someday be the master of the state. That's from Nazi Conspiracy and Aggression, from Mein Kampf. First laughed at as an extravagant figure of speech, the battle for the streets became a tragic reality when an organizing Sturmabteilung, I don't German, began to give practical effort to its slogan that possession of the streets is the key to power in the state. Present obstacle to mastery of the streets, either by... This is long. Man, how... Brother, you are writing... Okay. This is getting ridiculous. I'd be reading this for an hour. Look at all this. This is all him. Oh. Huh. Here's some important stuff. In the long, we get to the conclusion. Read my chats. What chats? Like the super chats? I will. Don't worry. Okay, here we go. Here's the last two paragraphs. In the long run, maintenance of free speech will be more endangered if the population can have no protection from the abuses which lead to violence. Speech will be more protected if we just get rid of what we don't like. Right? That's what he said. This is Chief Justice of the United States in 1949. If we just stop the speech we don't like, all speech will be more protected. I mean, except for this stuff, but all of the speech except what we don't like today, which might be different tomorrow. No liberty is made more secure by holding that its abuses are inseparable from its enjoyment. We must not forget that it is the free, democratic communities that ask us to trust them to maintain peace with liberty. But maintaining peace is stopping the violent mob, not the peaceful speaker. This is what's being missed here. And that the factions engaged in this battle are not interested permanently in either. What would it matter to Terminiello if the police batter up some communists? Nothing. He's not them. He should have no... You have no responsibility to another person's interaction with police. Only your own. Why should he care? People are throwing sticks, rocks, and ice picks at him and the police. Why does he care what the police do back? Or on the other hand, if the communists batter up some policemen, he might care about that. That's hard to say. Either result makes grist for his mill. Either would help promote hysteria and the demand for strong-arm methods, which this guy's literally asking for the state to intervene on speech, and he's talking about strong-arm methods and dealing with his adversaries. And what, on the other hand, have the communist agitators to lose from a battle with the police? Well, I mean, they can get beat up. Pepper sprayed. This court has gone far toward accepting the doctrine that civil liberty means the removal of all restraints from these crowds. That's not true. And that all local attempts to maintain order are impairments of the liberty of the citizen. No, just punishing them for speech, buddy. The choice is not between order and liberty. It is between liberty with order and anarchy without either. You sound like a statist. There is danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. I would affirm the conviction. Now, thank God, Jackson is wrong, and at worst case, we're back to 1949. But at best case, we haven't had a suicide pact, and it's been almost 70 years. Jackson's incorrect. No, it has been 70 years. Jackson was wrong. And we haven't, by the way, we haven't decreased free speech in line with Jackson's line of thinking. We've increased free speech. It's actually gotten better. So good job. I know that was a long way to it. Thank you for hanging with me through it. But we got to check these people. So the Atlantic writer is advocating for a policy that has been shown incorrect from a dissenting opinion that flatly would... Hey, Atlantic writer, if you were to ever engage in a public debate about guns and a bunch of Second Amendment fanatics showed up with guns and shot someone under the law Jackson was talking about, you would be fined for your rousing speech. You moron. Like, that's what this guy is saying. That if I stand up and pose an anti-gun question, and then a bunch of Second Amendment crazies show up open carrying and shoot someone in the crowd, I should be fined for my speech, which drove them to violence. That's what this guy's arguing for. That's what Robert Jackson was arguing for. This is crazy. It's insanity. Okay, I'm not gonna read through this. This is stupid. Let's just read the conclusion. Gun control advocates must reclaim the Constitution from the pro-gun lobby. That's the language of revolution right there. The March for Our Lives brief is a step towards building a constitutional architecture that makes room for these sidelined constitutional values, one that properly integrates law with reality. It recognizes the pain of those whose lives have been upended by the elevation of founding-era mythology above present-day tragedy. And by putting the gun violence permeating America's streets and schools directly in front of the Supreme Court, they actually see it. They do. They've actually declined to rule on cases that involve it. They've declined to hear them, but they see it. It gets brought up ad nauseum. And it gets brought up in Supreme Court arguments. And it gets brought up in amicus briefs. And it gets brought up in supporting petitions for cert. They've seen it, buddy. This isn't new. This isn't new. And lawmakers have seen it too. As it confronts a high-profile case, the brief ensures that this narrative will be heard. The student at Yale Law School, Joshua Feinzig and Joshua Zoffer, are students at Yale Law School. That's our future leading lawyers, ladies and gentlemen. Coming from the Ivy League law elite at Yale. These are the guys who will go on to be district court judges, appellate court judges. They'll go on to be Supreme Court judges. Feinzig and Zoffer, Yale Law School, assuming they graduate anywhere in their class above halfway. They'll have that Yale Law School credential. These are the solid thinkers with the solid research going into Chief Justice Robert Jackson's dissenting opinion that would call for their own censure if a mob happened to disagree with them. Good job, guys. Good job. That is the danger. That is the danger of law students, for one, and the danger of popular level legal writing in the Atlantic, for two. All right, guys. Let me go ahead and read the chats. Let me go ahead and read the chats here, and then we'll wrap up the show and go over to Twitch. This show went longer than 3 hours. What are you guys doing to me? Oh my god. Anani Moose says, where is the package? Oh wait, I read it already. Dang it. All right. Lumineer says, free super chat, Leighton Gay, Boomerus Maximus. Hey, thank you. D-Man Dog 056 says, hey, Nick, do you play Battlefield? I do not. I do not. Uno Kitsune says, free super chat for rackets. Didn't realize you sell sweatshirts. I do. And, I've got to talk to my guy about getting the How Embarrassing shirt back up. I apologize. We'll get it back up. And possibly Smirt says, good day to you too. Or good day to you. Hey, thanks. Dewey666 says, here's some more free Google money. Thank you so much. Nolan Void says, free super chat from YouTube. Thank you. I didn't know they were handing out free money. After Dark Recording says, yeet for Vic and 02. Eat it, Lemon Coon. I, Nick Racketeer, challenge you to a duel at dawn. Disco Jack says, don't usually get to watch live. Love the show. Hey, thanks, buddy. Tiny Kitsune 038 says, first time live in a while. Keep up the good work. Hey, welcome to the show, buddy. Character Holding says, it's hot. Nick 2019. It is. Uno Kitsune says, playing Baldur's Gate, taking a break from sewing, still have your shirt to finish. Oh, thank you. SM Scorks 89 says, your boy Zach, aka Richard Meyer, just launched Iron Sights 2 on Indiegogo. Back it if you haven't already. Can be bundled with the first one Wade is a baby. There you go, guys. Go find Iron Sights 2 on Indiegogo and give it a read or give it a purchase or whatever. After Dark Recording says, listen, Nikki, I better see some skin tonight. You better come to Twitch. Reek says, my weekend is Cheez-It. Here's some booze bucks. Thank you. Ross Fenwick says, free money. Thank you. After Dark Recording says, Nick, opinion on rum. I love whiskey, but I love Kraken. I'm not a big rum drinker in general. So I don't have many opinions on it. I have some on the shelf behind me, but I'm not a huge rum drinker, so I don't have much opinion on it. Enter the name here. Bohemian says, damn, Google finally knows my currency. Didn't know I pay for characters, though. My first and only super chat because freaky user cook cake for Kake for Google. Well, if you don't like Google, there is an alternative called Streamlabs. Character Holding says, love your show, bro. Fist gives me some outside perspective. Also, Epstein didn't kill himself. After Dark Recording says, last one, just sending some love. Thank you for your narcoleptic and beautiful rants for the fans. Hey, thank you. Uno Kitsune says, and last one, yay for super chats. Thank you. Thank you. Brian Dewey says, did you see the mail I sent you about super chats being copyright claimed? Really? Oh, yes. Yes. I don't know that that's actually true. That super chats are being copyright claimed. I don't know. I'll ask my guy on it because that's crazy. But I did actually. I have a similar issue where I had a demonetized video, and the dashboard, my creator dashboard, was not showing the super chats for that demonetized video unless I did some other things. So there's a weird display issue that I have asked about, and I'm hoping to get an answer on. But yes, I did see that. D-Man Dog 56 says, can Bethesda be sued for false advertising on Fallout 76? Probably not. It's really tough, but maybe. I mean, there's got to be a class action firm out there who will do it. Sergeant McSalty says, sufficient Kafifi. Some nobody says, would have loved doing Law, so much written smackdown sometimes. Some nobody says, this better not be a bitch down, will lose my mind. No. Johnny Drake, thank you for the donation. Burnt Zapato, thank you for the donations. Freighter J says, you just say Chup wants to get into the fifis? Yes. Andres K says, have you thought about going live earlier in the week at around 10 p.m. or 11 p.m. Eastern time? You might have a bigger audience. 12 a.m. is too late. I might, but there are people watching other shows at that time, and it's really hard for me to go live earlier because of my own family issues that I, like getting children fed and in bed and all of that stuff is really difficult to get things going earlier. Yes Man 2044 says, can I read the Ender's Game book without reading the short story first? Yes. Battle Room is Ender's Game is a massive expansion of Battle Room. You definitely do not need to read Battle Room. Sergeant F off says, how about no Chup November? New judge needed. Enter the QB says in Jay Sean's voice, I used the lawsuit to destroy the lawsuit. Nearly killed me, but the work is done. I am inevitable. Chris Nunez says, can I email a personal matter? Sure, buddy. Jason the Great Awakening sent cool. Thank you. Sean Clark says, did you see the fight with the Browns and Steelers? No, but I'm going to go watch it right away. Marcus Hollis says, the note on the bill didn't say dragon. It said drag on, as in drag on to the legal fees. Sean Clark says, if so, should Mason pursue legal action versus Garrett? I'll have to check. The Sean 2-3 says, Nick, I'm lost. What is a sheepdog that Ron keeps on talking about? Well, we know that Ron likes to threaten to murder dogs, so maybe that's what it is. Ricky1186 says, discovery that undermines the purpose of the TCPA. Yep, Foxhound364 says, here are my free super chats. Thank you so much for them. Colin4486 says, thanks for what you do. My pleasure. Do you enjoy vodka? And if so, what brand? $12 Costco American vodka seems as quality as Belvedere to my mouth muscle. I like Tito's. I like Ocean Organic Vodka. Okay. Those two. Those are my... Tito's is my go-to. Jason the Great Awakening says, I saw a YouTube chemist named Nile Red make moonshine from toilet paper. Will you commission a bottle for review? Oh, I saw the clip of that, or like the the thumbnail for that video, and I was like, no. Ricky1186 says, by the end of this, I bet Monica will be begging for the appeals to go through due to the bill they're going to get at the end of this. Bad Vibe says, those are log name redactions. Makes no sense to redact Ron and Monica, right? Of course. Luminaire says, do not pity Lemon. He hates and loves you almost as much as he hates and loves himself. Ricky1186 says, is it Kessler Collins? I don't know. The DCV Titan says, why is Ron's voice Kermit now? It just was. Unbeknownst TX says, got invited to the cookout. What do I bring? What cookout? I don't know. Bring brisket. That's probably tough. Bring a good batch of cowboy beans. Ricky1186 says, why redact the client in the billing? Is it not the same as the one in the filings? If not, then who paid you? Has Lemoyne been lying in his filings? Luminaire says, if Piggy's Marky smells like frog, she has issues. You called it a Marky. Ricky1186 says, what is hidden behind the redactions prove it wasn't a frivolous lawsuit? If so, what would that do to the overall case? I don't know. Mistis Nikoto says, investigate plaintiff online equals watching dubs with Vic. Jason the Great Awakening says, everyone in chat say, hi, Andrea. Hi, Andrea. Last Sigil says, bastard of Lauren. Jason the Great Awakening says, why no line item for Viagra? That's a good question. Bad Vibe says, client Funimation. Wait, what? Is this why Moronica stopped trying to hitch their wagon by motion to Funimation? Alex P10V2 says, Casey saying Funimation is client. Everyone else, sniff, sniff. I love the smell of conspiracy in the morning. Kalinka Pavlova says, ha 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 ha, Ron lying under oath. Dark Knight says, cookie, me love cookies. His voice is weird. I don't like it. Philip Rep says, I've tried Woodford Reserve, Chivas Regal, and Glenlivet 12. Where do you think they rank? If you've had all of them, also run recommendations. I've not had Chivas Regal. I would go with Glen 12 over Woodford just because I like Scotch a little bit more than bourbon. Phoenix Lord Asserman says, if you're going to talk Taylor, you need to wear the Greer lips. We should do... Coming for you, Taylor. Some nobody says she has insane money. Why does she care at all? Kalinka says, if Bruschetta and Braun have no rights to Swift's music because they didn't write it, but they own it, do I have to give my clothes back to the manufacturer? Yes. Some nobody says, Nick, her lawyers told her to do this, obviously. Yeah, I know. Nya says, imagine being as rich as T Swift and still a victim. Some nobody says, ooh, she wants to use the AMA recordings on Netflix. Senpai is home. Says, hashtag the grift is real, Nikki. Rick Nikita says, fill me in on what I missed from the beginning, please. Just start over. Freighter J says, all we need to do is make all crimes illegal. Then no one will engage in crime. Boom, society is fixed. You're welcome, America. Ryan Gordon says, another big purpose of the Second Amendment. Who would invade a country with 300 million gun carriers? Supposed to be a militia. Yep. Some nobody says, never mind, number one gun murder champion is the government. Brandon Cavallero says, have you heard of Onision? He's a YouTube predator who's currently being investigated by Chris Hansen. Would love you to cover the potential legal stuff. I have. I've been holding off on covering Onision because a lot of people talk about him. But maybe it's time. Gabriel Eving says, short on money at the moment, Rackets, but you are twice as likely to die in a car crash than by gun homicide via CDC stats. We need common sense car control. Ryan Gordon says, if people don't want freedom to carry firearms, then they can move their closet biscuit eating tea sipping asses across the pond. Britain would take them. RickU1186 says, Australia reached that point where both sides came together for gun control, and today is the only thing 95% of politics agree on. Jason of the Great Awakening says, where do I collect my constitutionally allowed tactical nuclear weapon? Sorry, buddy. You cannot. You cannot. Bill Gates can, though. Jason the Great Awakening says Congress isn't meant to orange man bad. No, it is. It is. Some nobody says, this is why, by the way, nobody likes the left. They don't think about the facts or try to problem solve. All they do is insist upon their ideological position. Corey Goodman says, will your Ridge wallet code still work in December? Probably. I was planning on getting a carbon fiber one before Christmas if it'll still be working. I don't see why it wouldn't. I think our agreement is to go through Christmas, so should be good. Nya says 70 years later and mobs still call people fascists. Corey Goodman says, and congrats on taking my super chat cherry. Felt necessary to tell you it was my first time. Hey, thanks, buddy. DCV Titan says, sounds awfully like whose streets are streets. Anime Moon says, just finished catch up. Why do I now have the suspicion that Jay Sean was hired and paid for by one Christopher Sabat? Plot thickens. Comicsgate Live says it's okay to be Jewish. It is. It is really okay to be Jewish. Stuart Postma says, I can answer your RM question. Bumbo have a hard time. Keep it on the shelf at my liquor store. What? Bumbo. I have a hard time keeping it on my shelf at my liquor store. Okay. Right. Next, we've got Ron's ex-wife's dog says, bark, bark, woof, woof. I have information leading to the arrest of Hillary Clinton. Mercenary X says, Nick, the whole YouTube voice was basic. Leave the pimp and everyone who makes videos on YouTube as the you know what period. It sounds familiar, but I can't place where the quote was. It sounds familiar, almost like Jeffrey Epstein didn't kill himself. Jden M8 says, over 3 hours for that PowerPoint that Chup didn't even want to see. Yep. Bad Dragonite says, any chance of doing a show on the 100K Pornhub performers who got canceled by PayPal? Possibly with Dick and Drex. I'd love to. I'd love to. LaPierre Hammer for prison says, if the Second Amendment can be restricted, so can the 13th. Democrats already publicly demonstrated their desire for such restrictions on February 19th, 1942, if not earlier. We've already seen where their marvelously elastic view of the Constitution leads. Mercenary X says, I only have one thing to say to these people about gun control when they ask how many people or children have to die before you agree all guns need to go. Me, all of them, no exceptions ever. I will never give them anything close to an inch. Nepal Gyandi says, Nick, you said you're mainly Polish with some French. What's your full ancestry? It's like almost all of Europe, man. I don't know. There's French, Dutch, German, probably not as much Spanish or Portuguese. I don't think there's any like Southeast. I don't know if I have any Italian. But there's just a mix. It's a big mix. It's a mess. Just a disgusting, disgusting mess. And I don't know all of it, frankly. I don't know all of it. I don't care. Some people put a lot of emphasis on that and want to know their origins. I don't. Doesn't bother me. Okay, Big Red Bear says Epstein did kill himself because being a potential rat to the wrong people is definitely making a choice that's going to lead to your own death. Now that is novel and true. That is novel and true. Anybody who thought Epstein was going to make it out of that cell was fooling themselves. Let's start this. Let me get. There we are. Oh yeah. Oh, there we go. There's some outro music. We're gonna be ending the show here. Thank you all for hanging out. Stuart Postma says it's pronounced bumbu and I meant to say rum. Sorry. Okay, so rum. Stuart Postma says bumbu. Bumbu rum. So there you go. You want a rum? Go get bumbu. Matthew Beckema says, here's the free money Google gave me in exchange for my soul. Oh, thank you so much. I'm glad that your soul is being put to my use. I really do appreciate it. All right, guys. Thanks for hanging out with me on a Saturday. I know it's not my normal streaming time. Stay tuned next week. We will have Camelot on. I assume we will see some news about what the ruling on this motion for continuance is. I'm guessing at some point, probably depends on when the motion for continuance is ruled on. At some point, we're going to see the judge or a motion, or the opposition to the motion for the fees. Like Vic's team will have to have some sort of filing that they'll probably drop really soon. Unless they get their continuance, then they'll have some more time. So, but we'll be monitoring and watching. Stay tuned if you're interested in that stuff. All right, guys. I hope you have a wonderful evening. Enjoy yourselves. Enjoy each other. And if you want, come watch me thought it out on Twitch. Peace. Peace.
Bring that perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea. Post on Twitter as we hear lost painting tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the throng better than Nick. So pour out a glass for